check. Honorable Nyonzo, are you there? Honorable Nyonzo? Honorable Majosi?
I'm here, Chairperson. I'm here.
Thank you. I appreciate it. It's exactly 2 o'clock. We're resuming our session. I now hand over to Advocate Mpofu to continue.
Thank you. Good afternoon, Chairperson. Good afternoon, Mr. Tebele.
Good afternoon, Advocate Mpofu and Honorable Chair and members.
Thank you. Yes, Rad, thank you. We stopped where you were emphasizing that Advocate Mkobane was determined that when she leaves in October 2023, there should not be a backlog, except, of course, as you correctly pointed out, you can't help it if there's a matter that just came a month before her departure, but that there should be a minimal backlog, correct?
Correct, Advocate, through you, Chair.
And this was communicated to the team as one of her goals, correct?
It was comments that she would make in a meeting, which she will indicate that it is my wish that when I leave, we should have matters at least that are dating this and this period.
Yes.
And in those meetings that I would have attended, that is what I would have had.
Communicated. Yeah. Thank you. Now, you also said that you have experienced the public protector raising her voice in meetings when deadlines have not been met. I suppose, like any boss, I was certainly a boss who used to do more than raise my voice. Yeah. Did you find that to be unusual in your experience?
No, it's mostly not unusual because sometimes certain circumstances they can force you to do that. As much as maybe as subordinates, we are not used maybe to it, or we may not appreciate it, but it does happen when certain circumstances force somebody to say that. Yes.
And in your experience, when would those kinds of circumstances arise? When she would raise her voice, it would be when what happened or what did not happen?
Mostly it will be when certain commitments were not met in terms of a previous arrangement, or maybe when she learned through a complainant that phoned her directly that this particular matter has been there and I have had nothing. And when she engaged with the investigation, she found that the matter has not really been receiving attention. Those are matters under which a voice will be raised. Yes. And I mean, really a voice will be raised, and I don't want to beat around the bush, even to the extent that she will even say, but guys, just tell me, why are you here? And why should these people trust that we are doing their service, and when we are just sitting here and doing nothing?
Yes.
That is the type of voice that I would have had in the meetings that I would have attended.
Thank you. So even those instances would have been focused on service delivery, improvements of service delivery, or what the chairperson of the portfolio committee, Honorable Mangwanisha, has called the improved performance. It was to achieve the improved performance of that office, correct?
It's correct. All what I could say is, though, whatever was said during these meetings, it was said because of the work that was going on. And I'm not aware of anything that would have been said that was not related to that type of work that we were looking at.
Thank you very much. And I mean, if all this was related to service delivery, it would be a sad day, I'm sure you'd agree with me, when in a country that is plagued by lack of service delivery, that we might have reached a stage now where we have to fire people or impeach them for insisting on service delivery. I'm sure you'd agree with that.
That one, advocate, I wouldn't want to preempt the outcome in terms of the areas, but what I'm putting forward is my observations and what I have seen for the period that I stayed in private office, which was almost a year and a half.
Yes.
And the interactions that I had with the public protector and the teams that were coming to account to the public protector.
Thank you. And you are sharing your own experiences.
Yes, I'm sharing my own experience.
Fair enough. Fair enough. Okay. Now let's go to the issue of dashboard. You've described, I think, 3 types of meetings. The think tank, which was abolished, you spoke about earlier. The task team meetings, the weekly task team meetings. But as I understand it, there was also a monthly meeting called dashboard. What would happen in those meetings that was different from the other 2 meetings?
Thanks, Advocate, and through you, Chair and honorable members. There were meetings that the public protector would bring the investigation team to account. That was the task team that happened weekly and the dashboard. So in dashboards, various EMs will present the status of their investigations, whether they are at the point of Section 7.9 or report writing. But the dashboard was basically to look at how far are matters that are under investigation. So each EM will present their list and give an update of where the matters are. What made it distinct from task team is task team would take over a matter that served in dashboard. Once the matter goes to report writing, then the task team will take over that matter into their list and start monitoring that matter on a weekly basis. But there were instances where there will be overlap in terms of the matters that are monitored under task team and dashboard. But dashboard was mostly operational, looking at the investigation and how far it's what matter. And I happened to be the scribe in that meeting during my time. I'm not sure if that has changed now since I left.
Good. All right. By the way, you said, you remember in relation to the information leakage crisis that your laptop was also taken. When it was returned, was there anything unusual or was there anything missing from it?
I couldn't pick up anything, maybe to the extent that I was not looking for that information. So I wouldn't even know if something was missing in my laptop.
Thank you. All right. Then if we can go to the issue you raised in, I think it's paragraph 38 of your affidavit where you talk about the impact of the Nkandla judgment on the number of court cases. In fact, let me, it's paragraph 38, yes, Chairperson, is page 2561, at least on my version of the document. I'll just read it out and then I'll ask you to comment, Mr. Tebele. You said increasing litigation involving the Office of the Public Protector appears to have occurred because of the approach adopted by the courts, making remedial action binding and hence increasing litigation because those who were obliged to comply with these remedial actions and recommendations seek to go to the courts to have such set aside instead of complying with the remedial action. I got the impression that institutions sought to take the Office of the Public Protector reports on judicial review rather than to comply with a particular remedial action. This would happen when those institutions were called on to indicate how they complied with the prescribed remedial action, i.e., when the remedial action was sought to be enforced. Such legal proceedings were sometimes initiated even years after the remedial action was supposed to have been actioned, and then only because the PP's office sought implementation of its recommendations. Even on what I regard as being bread and butter issues, reports are now being taken on review, forcing the Office of the Public Protector to oppose litigation in order to defend reports that have been issued. You remember making that statement?
Yes, I remember, Advocate.
Yes. And can you just for the edification of the committee, explain how much of an impact or how much of a turning point that EFF Nkandla decision made in terms of the flow of litigation in the office?
Thanks, Advocate, through you, Chair. From our observation, because part of the role that I played was in legal services, and constantly the portfolio committee would require certain information in terms of litigation costs. And at some point, we looked at the period before Nkandla and the period after Nkandla in trying to understand what could be causing the spike in our litigation costs. And we came to the conclusion that because of the binding nature of the remedial actions, it is no longer easy for institutions to ignore the remedial action when the public protector has issued the report. And in the institution, we do have a dedicated person who follows up on remedial action, who try to check with institutions how far are they in terms of implementation. And our reading of the whole thing was that we are getting this spike because now they are binding and people can no longer ignore them. Those that are ignoring them, they can ignore them to the extent that the public protector is not coming to them to say, how far are you? But once you push enforcement on the other side, also, the reviews are also coming in terms of our observation. That is on the basis of that we came to that conclusion.
No, thank you very much. And is it also a fact that the rate of litigation or the nature of the litigation would mostly be that the Public Protector's Office would be responding to review applications rather than initiating such litigation?
Most of our matters, when I last interacted, was that most of our matters, it's where the initiators are not, it's not the public protector, is coming from outside, which means we are being dragged to court. And then at some point, then we are forced to oppose or not to oppose, sometimes looking at our financial constraints. But it is correct that we are getting more litigation from outside than our own initiation, because I would think that as much as we would want to enforce our remedial actions, due to financial constraints, we are inhibited by those constraints because you must litigate on behalf of the complainants. That is what it will literally mean.
Yes, and the evidence of the public protector will also be that in those circumstances, when, as you say, you are dragged to court, it's impossible to predict how many reviews are going to come and whether they will be successful or unsuccessful, or whether they will end at the High Court stage or go right up to the Constitutional Court. I'm sure you'd agree with that as a lawyer, just in your own general experience, that litigation is by its nature unpredictable, correct?
It is correct, because you can't determine how far you will go in the court process from the word go.
Yes, thank you. And is it also a fact that the number of reviews would be proportional to the output? In other words, you might be a victim of your own successes. So, for example, one of the statistics that the public protector will put up when she gives evidence will be that in the era of Advocate Madonsela, there were 11, I think, reports in that 7-year period, which related to EMEA, you know, EMEA, the Executive Members Ethics Act. And in her period, which is still more than a year away, she has already done 37 of those by comparison. And the point I'm making is that and these are the high-level investigations of members of the executive. If you do more, then obviously the reviews, particularly post-Nkandla, will also be more, because the 11 that she did were mostly before even the Nkandla case. Would you agree with that analysis of the public protector?
Advocate, it may not be an exact science in terms of the reports that you issue and the review, but it should follow that the more you issue reports, the possibility is you are likely to get more reviews in what you are issuing. Yeah. We can paint another scenario where you don't issue any report for the whole year. You are definitely sure that you will never get any review unless the review belongs to some report that you issued somewhere. So it's just what I would want to paint, yes, without really going into details in terms of what it means, but that is how I would take it as of now.
No, thank you. That's correct, yeah. The safest way to get 0 reviews would be to do 0 reports. I agree with that. All right. Now, I just want you to assist us. In fact, you did. Just maybe to assist with another area of what seems to be potential confusion. In your paragraph 5, and I'm sure you've found many people being subject to this confusion that I'm going to refer to. You clarify the difference between the institution and, sorry, can you still hear me, Mr. Tabele?
Correct, Advocate Mbofu, through the chair.
Sorry. Yeah, there was a minute where I had a blank screen. Okay. I was going to say, yeah, you may want to assist the committee also in navigating this area about the public protector, the person, and the office of the public protector, which is the institution, and sometimes even used as the OPP, I think is what you use in your statement. But sometimes it's just simply called the public protector, meaning both the person and the institutions. In paragraph 5, you say, when I refer to the PP herein, I'm referring to Advocate Mkhwebane. When I refer to the OPP, I'm referring to the Office of the Public Protector, i.e. the constitutional institution inclusive of all staff members. Am I correct that your second, what you call the OPP, is the juristic person that is referred to in Section 5 of the PP Act, as opposed to the person, correct?
Correct, Advocate. The terminology that I came to learn when I came to the institution is the PP and the DPP, and the institution being the Office of the Public Protector. But currently, we also use PPSA, which is Public Protector South Africa. I think interchangeably meaning the Office of the Public Protector. So sometimes it could be confusing in terms of, but I was giving my interpretation so that people can understand when I use certain words, what am I referring to? So the PP would mean the current public protector, Advocate Mkhwebane, and then there will be the DPP, and then the Office of the Public Protector would mean the institution together with the staff. That was for the purpose of clarifying these words when I made the paragraph and my role.
Thank you. No, thank you very much for that. Yeah, no, I think for people who are outside the institution, some of them find it unnecessarily confusing. I know some very senior counsel who still can't work that one out. But you're quite right that the OPP in your language is sometimes used interchangeably as PPSA, simply to mean the institution. Correct?
Correct.
Thank you. All right. Another area of potential confusion, which I started you with, is also, I think it also manifested itself yesterday, and that's around the issue of what I call, I think it was referred to yesterday, is the separate lanes of the public protector, as executive authority, and the CEO as the accounting officer, which you have correctly pointed out converge at certain places and separate at certain places, as it would happen because you are dealing with one institution, these people are servicing. But I want to ask you around that issue now, specifically around the issue of disciplinary proceedings, because I think that's where the potential confusion was. It is correct, isn't it, that disciplinary proceedings are run from or conducted from the office of the CEO, correct?
It is correct because from what I know, the accounting officer is the one responsible for disciplinary action.
Correct. But having said that, and this is where I think there's confusion. The public protector herself, or the DPP for that matter, is part of the institution. So if some employee, let's say, insulted the DPP or did something, there would be nothing to stop the DPP from referring a matter to the accounting officer to say, this person has just called me names, and therefore, for that matter, then the process of discipline would continue because all these people are working within the same institution. Am I correct?
Yeah, I think to the extent that the executive authority maybe don't have disciplinary powers, but where the executive authority feels that in my present, one staff member behaved differently, and maybe there are people that could attest to that, then I think that they can ask the accounting officer to institute those disciplinary processes, which will mean that the information on the disciplinary processes would come from the complainant, who will now become the public protector, in case it's the public protector, or the DPP, because that's the person that must give the statement for the initial process to start. That will be my thinking in terms of procedurally how we would want to do it.
Yes, no, that seems to be correct. And in fact, you're right, the PP in my example, or the DPP, might even be called as a witness once the DC has started. Correct?
Correct, because that's the first complainant, is the initiator of the whole disciplinary process.
Yes. Now, but that must not be confused to mean then that the public protector or the DPP in that example would be conducting the disciplinary process. As you say, there might be an initiator because of the factual circumstances, but they have no power to conduct a disciplinary process. Am I right?
Well, in terms of the disciplinary codes, the institution needs to appoint independent people to investigate the matter and to assess whether the disciplinary process will continue or not. I think the investigation is the one that will determine if this matter is proceeding forward or not. But it wouldn't be the complainant that is going to be part of the process, except to give evidence.
Thank you. Right, okay. And then you've touched on exactly the next point which I wanted to deal with. In your experience, the persons who were disciplined, either in the period that you were there, did you ever get the impression that there was some campaign to purge people, or would it be case by case? Whenever something was found in relation to a person, then that person would be disciplined, and obviously they'll either win the case or lose the case. I mean, that's out of your hands. I'm just talking about the initiation stage. Did you find that there was some I don't know, targeting of certain people, or did it depend on whatever came out of the system?
No, I was not involved in the disciplinary processes, and as a matter of principle, even if I was overseeing HR, I indicated to them on several occasions that I don't want to be involved in labor relations, because there is a labor relations unit that deals with the matters. So I will rather observe from my own area without being inside it. So it has always been handled by labor relations, and I did not even want anybody to report to me about what is happening on the disciplinary processes. And as such, I really did not have any information in terms of what was happening, whether it could have been patching or it was relating to work. But I know that there were certain officials that were suspended, and then disciplinary processes had taken place.
Okay, no, fair enough. But just as an observer then, would you, and if you can remember, what I'm trying to say, was there ever a period where they would say, you know, there are these 10 people, there's some wave of people who are being suspended for the same thing, or did these things happen at different times depending on whatever is happening in a particular department?
No, my observation, I wouldn't have thought there was a wholesale suspension. I wouldn't have said that because it will be a fraction of the people that were really suspended and the staff complement that is there. So I'm unable to make that assessment because I don't have the numbers in terms of who was suspended and for what. And out of that number, what is the proportionate number to the number of staff that we have to come to the conclusion that there was this wholesale suspensions or.
Thank you. And then just to confirm, I think Mr. Mahlangu testified to this, but since you are now working in the CEO's office, am I correct that the modus operandi is the same? As you've already said, there will be a complaint, it will be referred, and so on, up to that stage. Now, from that stage onwards, am I correct that the modus operandi would be that an independent law firm would be appointed to investigate the veracity of the charges, just like this committee?
I think what the labor relations do is they do get.
Or rather, sorry, I should have said just like the independent panel to first do an assessment whether there's a prima facie case, a case, what we call a case to answer.
I think that exercise, labor relations does that exercise. They appoint their own, I won't say an attorney, but I think they can appoint anyone who can assist them with investigating a matter to advise them in terms of how to proceed. I think that is what they do. And in certain circumstances, they can even appoint somebody internally that they think is not involved in the matter. Because some of these referrals, they involve finance. You appoint people and you pay, but they do get independent people, and including lawyers, they can get anybody.
Yes, no, but the principle is that you get someone independent, not someone conflicted. Unlike certain situations, there would be no, and you're quite right that if the problem had to do with accounting, it might be that they appoint accountants. It didn't invariably have to be lawyers. But the emphasis I'm making is whether it's an internal person, whether it's an accountant, whether it's a lawyer, the investigation of the prima facie case would be done by an independent party. Maybe let's just put it like that. Correct?
Yes, that is the procedure.
Thanks. And then once the report then comes and says, yes, there is a case to answer, not necessarily that the person is guilty, then is it correct in your experience that then yet another independent person would be appointed to chair the actual disciplinary hearing? And that's the one I can say, which is like this committee, where they will then have to find the guilt or innocence of the person. Am I correct?
Procedurally, a person needs to be appointed to chair the proceedings. We will always say an independent person, but the independent person can also come from internal. But it is a standard process that you need to appoint a person that is at least perceived to be independent to chair the proceedings. Whether internal or you go external, but the process is, for the process to be fair, you need to get that independent person to chair the proceedings.
Yes, and in respect of senior people, that would almost invariably be an independent advocate, or an external advocate or attorney, although, as you say, it could be theoretically an internal person as well.
I don't think that the procedures will tell you that in this rank, you need to appoint this rank of a person. As far as possible, you are trying to investigate a matter, and you are trying to get people that can assist you in the matter, so that when the matter goes forward, you are sure of the story. So I don't think that there is a relationship between the seniority of the person. Yes, we can, as people, we can say, because this is a senior person, then we may need somebody who's got more senior experience,
Yes.
because we will need to match the experience. But I don't think that the rules or the procedure tells you that if it is a senior person, you must appoint an SC or somebody who has served 10 years or 15 years. No, the rules would not say that.
Right. Okay. Let's accept that it might or might not be like that in the code. But in your experience, the persons that we have mentioned in this particular inquiry, they are disciplinary hearings, to your knowledge, if you know, would have been chaired by external independent parties. Correct. The ones that you know or the ones that you heard of, even, I don't know, before you got into the CEO's office. Correct?
I don't even know that the persons that were chairing the hearings.
Okay.
That is to the extent that I indicated that as an employee of the institution and interacting with employees on various levels, if I know who is dealing with this matter, it may end up conflicting me in terms of me understanding how far is the process. So labor relations during my time, they knew they were not reporting to me in terms of labor matters, as long as they follow the right process, so that our matters, when they go to the CCMA or wherever, then on procedure, we are not found wanting. I really moved away from managing inside disciplinary processes during my stay in labor relations. I left it to HR and labor relations, to the extent that I didn't even know who were chairing those meetings. And I didn't even know the reports that they got. They never even showed me the reports. Yes. And I would even just refuse to say, you have independent advisors, deal with them the way that you're dealing with them, so that I don't come into the picture.
Okay. No, that's fine, Mr. Tebele. I thought if you don't know, you don't know. Yeah. The evidence before this committee is that, well, at least the people that we have seen, Mr. Kekada and Mr. Samuel, have confirmed that in both cases, their disciplinary hearings were chaired by independent advocates. That's fine. But to your knowledge of the rules, it would follow, therefore, because you are saying that the emphasis was on independence, whether it was an external person or an internal person, but the charged employee would have a right to object if they felt that the chairperson was biased or conflicted or not independent, correct?
Yeah, I think that is given in any proceedings. If you are not happy with the chair, you can raise your voice and you can even request recusal. I think that rule is applicable in those circumstances.
Yeah, well, in certain circumstances, it doesn't make any difference. But at least they would have a right to raise it. Okay. Right, the last topic that I want to deal with you, or rather to deal with you, Mr. Tebele, is the issue of the Audi letters. It is indeed so that you yourself was a recipient of such a letter, correct?
Correct.
And just to take away the Latin, what we really mean is what is commonly known as a first warning, correct?
Correct. Well, there are different warnings, be it verbal, be it written. So an Audi letter, I will take it, it's a written warning because we get a letter.
Correct, yes. In most disciplinary codes, it would simply be called the first written warning. Okay. I mean, terminology might differ, but the effect, as you say, is that it should be a written warning. Am I correct that even that Audi letter, and let's talk about you now in your concrete situation, it would have come after some, maybe let's call it verbal warning. After you have been told you have a deadline, for example, and you have not met the deadline, and then you get told again, and then at some stage you get the Audi letter. In other words, it can be the very first thing without you not even knowing what you have done wrong, correct?
I would take it that procedurally there should have been something before the written warning. There should have been something that you have been warned against, and now they are putting it in writing. That would be my thinking in terms of process. Because if I don't know that I'm supposed to do something, and the only way I know is to get the letter, that I would think is unfair under the circumstances.
Yes, thank you. No, that follows logically. And in your instance, you've said that I don't want to put words in your mouth. You said at paragraph 49, I have received an Audi letter from Acting Chief of Staff, and I was not under the impression that this had been orchestrated by the Public Protector at all, as it related to me not having properly submitted a performance agreement. So in your case, it was a failure to submit a performance agreement, correct?
Correct.
And once you delivered on that and produced the performance agreement, that was the end of the matter, correct?
Yeah, it ended there. Normally, an Audi letter will indicate that within this particular period, you may not need to do the same. And after this, then the Audi letter will be withdrawn from your file if it was indeed in your file.
Yes. And yes, I know. I don't want to talk in theory now. I'm talking about you specifically. Once you delivered on the failure to deliver that agreement, that was the end of the matter. Nobody took the matter any further or took you to a disciplinary hearing or anything like that.
No, in my case, it ended after the submission.
Yes, as it should. Okay, and you never saw this as what Advocate Mayosi calls harassment, intimidation, and victimization, did you?
During my stay in private office, which was from June 2017 to around 2018 October, I would not really talk about having seen a harassment or patching of people. Maybe I could not be understanding what a harassment means, but in terms of where I'm sitting, the issues that were being dealt with mostly related to the work, whether the voice was raised or not raised. Maybe from my side, I wouldn't have taken it to be a harassment, but it's a different thing altogether in terms of what is harassment. But myself, I've not experienced it, and I can't say in front of me during my presence that this harassment happened while I was in a meeting with the public protector or with whoever was harassed. I wouldn't say that.
Thank you. And again, to bring it home to you specifically, the fact that you had failed to perform and you were given an Audi letter, You never perceived it as harassment, intimidation, or victimization, did you?
No, I've never seen it, although it was a culture shock for me because it happened for the first time in my career.
Yeah.
But I looked at it, then I said, well, anyway, I had my own view in terms of not submitting the performance agreement because I think it was my first year where I expected the employer to give me a performance agreement. And the employer was expecting me to draft my own performance agreement. And that was a different thing. That is why I did not comply. So that is how I perceived it. And the person who gave me the warning, we continued to relate even up to today. So it was never personal. It was relating to that. And I gave the performance agreement, and that was it.
Yeah, thank you, Mr. Tubel. All I can say is that you are a man of integrity and approach things in a professional manner. We need more like you in our public service. Then finally, at paragraph 50, you say this, and I just want you to comment if you want or to confirm. You say, as I saw it, when Audi letters were issued, it was because promised reports were not being delivered, deadlines were not being met, proper quality assurance was not taking place. The Audi letters were received by employees because of what they were failing to achieve. Do you stand by that, or would you like to confirm that that is still your view?
Yes, during my stay, Audi letters were basically about work or maybe certain misdemeanors that would be relating to work. But I wouldn't have seen an Audi letter that would have been done under different circumstances unless those that received the Audi letters can show that this Audi letter was done for something that did not happen within the area of my work. That is my observation, because at some point also HR was requested to look at these issues of Audi letters, because I think it was also raised by unions that there are a lot of Audi letters that are going on in the institution. And as such, the institution, the employees become demoralized in terms of the nature of work. I think HR tried to handle it in that regard. But I will stand by the paragraph in terms of the Audi letters that I would have observed unless proven otherwise.
Thank you. As I understand it, despite the attempt to show you that SMS just before your testimony, you remain of the view that you remain of the views of the positive views that you have expressed regarding the efforts and endeavors of the public protector to improve service delivery to our people, correct?
To the extent that the focus has always been about the work, for me, I am okay. The issue of management, people differ in their management style, whether you like it or not. There is this saying that you get a boss from hell. I'm sorry about my language, but those are the things that you get. But the focus that I have been seeing, heavy-handedness, or those words that are saying they were reprimanded, for me, they were about work. I'm not aware of anyone that was not about the deliverables that were supposed to happen. And I think I will stay and stand by that, even up to now.
Yes, and in your experience, I'm sure, like all of us, you've had different bosses in your career, and they differ in their style, as you say. And but your testimony is that the benefit in this particular instance was to the people, to the beneficiaries, or rather the complainants and the public that, after all, you are employed to protect, correct?
Correct. It was about work. As much as I would have felt that at a certain point, the public protector became too operational. But that is the style in which she wanted to run the institution, and that is the observation that maybe she made. And she thought if she do that, then things will move. Because from where I'm coming from, you are not used to an executive authority who is very, very, very close to the fire. They were always aloof. But when you come here, it's a different culture. But after observing the culture, then you can see the reason why things are happening the way they are happening. And that has been my observation. I don't know if things have changed. I still have some interactions with the investigations. Being in the CEO's office, I'm not sure, but I don't attend most of their meetings now. Maybe things would have changed. But that is what I observed during my stay until October 2018.
Yes, and the results are there for all to see. I think they are in the annual reports. Correct. Would you agree, Mr. Tebel? No, I'm saying the results are there for all to see in the annual reports and the statistics of the public office of the public protector.
I would say the performance of the institution, it's there for people to see in terms of the performance. That's the only way in which I can gauge if the current management is doing the right thing or not. It's only in terms of the performance.
Yes, as the Bible says, let those who have eyes see. Now, finally, this time, Chairperson, there's another, it's just a small area of blurred understanding. Am I correct in the following statement? Although the CEO's office where you are working now is not involved in conducting investigations, but as the accounting officer, the CEO gets engaged by external stakeholders with complaints or all sorts of things to do with investigations. And those investigations have to be, or rather, those complaints have to be processed at that level. But that does not mean that the CEO actually does an investigation. So that's another area of overlap. Am I correct?
My current observation is the CEO is now involved in investigation other than the previous ones. And there are a lot of complaints that go directly to the CEO, and most of them, or some of them, get referred by the public protector. So the situation has changed. Before, now the CEO is the one that has to submit information through to the private office, which is the Office of the Public Protector and the Deputy Public Protector. So our current CEO is much involved in terms of managing the investigation.
Yes, more hands-on, yes. But again, as you, I think your last two words were of managing the investigations. In other words, that would also involve things like what you and I have discussed, the turnaround times, making sure that the dashboard targets, for lack of a better words, are being managed and the deadlines are being followed and that kind of thing, which is part and parcel of the investigation, even though the core investigation might be done by the investigators. Is that more or less the relationship between the two arms?
Yeah, the CEO, although I'm not speaking for on behalf, but the current CEO is always in investigation meetings.
Yes.
It's always making follow-ups in terms of the deadlines that the investigators would have promised. So it's a different scenario now with the current CEO. It's unlike before. Unlike before, the previous CEOs wouldn't even attend your dashboard meetings or your investigations, but the current one is busy on that. And because maybe a background also comes from investigation background, that is why she's doing what she's doing. That is all what I can observe. But she's currently managing things in investigation and also reporting to the executive authority in terms of how things are shaping up.
Yes. Thank you. And that's a positive development in the sense that at least when she's managing the deadlines, she'll be knowing what she's talking about because she attends the investigation meetings as well. Correct?
Correct.
Thank you very much, Mr. Tebele. You've been a breath of fresh air. And as I say, I meant it. I was not patronizing you. I mean it. If I was still a CEO, I would have liked to have somebody like you working in my organization. Thank you very much. Thank you, Chairperson.
Thank you, Advocate Mpofu, and thank you to Mr. Tebele. We now proceed to members. I'm going to invite members. Those of you don't have to, all of you, those of you who have an interest to interact with Mr. Tebele, as we always do. So I want to now note all of you who are now interested to interact. I'm going to start with Honorable Dlagude, followed by Honorable Majosi, Honorable Mailam, Lucas, Honorable Masaule, Honorable Heron, Honorable Tolangola, Honorable Kosana, in that order.
Thank you very much.
Wait, Honorable Dlagude, Honorable Gonde. Thank you. Honorable Ngosi. Mautwe. King. Thank you. Honorable Dlagude, please kick.
Thank you very much, Honorable Chairperson. Good afternoon to you, the PPNA team and my colleagues. Honorable Chair, Mr. Tebele, good afternoon.
Good afternoon, Honorable Member.
Thank you very much. You said in paragraph 5 of your affidavit that you were responsible, amongst other things, quality assurance of reports when you work in the private office of the public protector. Is that correct?
Correct.
Okay. Since you were responsible for quality assurance of reports, did you do quality assurance on the CX report?
Thank you, Honorable Member. In my presentation, I indicated that the CX report, when I got to the institution, it was done. My involvement in it was the editorial, which I could just call it a grammarly, spelling errors and stuff, because the report was almost at the stage where the public protector was considering it for finality when I joined the institution.
Okay. Thank you very much, Honorable Chairperson. Mr. Tebelo, what is the role of the public protector in the process of quality assurance of reports?
The role of the public protector is to set up systems in terms of how report should flow from the investigation to the public protector. The quality assurance is one of those systems that is there. And because the work that investigators do, quality assure, at the end of the day, they go to the public protector. And the public protector will look at the report, go through the report, and if the public protector has anything that they are not comfortable with, they are likely to say, this report must go back. Can you please penalty the following areas? Because they are the ultimate person. But their role in the value chain, they get the report after everybody would have seen it and after it has gone through the stages, unless the stage where they are only involved in terms of guiding the investigation process.
Okay, thank you very much, Mr. Tebelo. There are allegations through you, Chairperson, that were made against the PP that should instruct people to change the reports, or the reports will be just released without it being quality assured by yourselves who are responsible for that. Is that true? Mr. Kekana, in his evidence, when giving evidence, he said that sometimes the reports were released without being quality assured. Is that true?
I wouldn't know why it will not be quality assured, because Mr. Kekana was in the quality assurance team. The quality assurance team, it was Mr. Kekana, Matlawe, Raidani, and there were several others who were junior. But those formed the quality assurance team. So I wouldn't know if they say a report was issued without being quality assured. What are they referring to? Because the quality assurance must be done by the person who drafted the report, and then it must go to the senior investigator or to who the person is reporting to. And there is a chief investigator who must also see the report. And there is an executive manager who must also see the report. So if they are saying without it being quality assured, I wouldn't be sure in terms of what would have happened. Did it move from the investigator to the public protector without anybody seeing it? That one I wouldn't know. Because he was in quality assurance, maybe he's the one who would know better, because he was in the quality assurance. And my role in the executive office, I was not really part of the quality assurance team. Quality assurance was independent. My role was to assist the public protector on reports that are going to her, to the extent that I would understand that this report maybe is not correct here and there. That was my role. But the quality assurance team were the ones who would instruct that, you know, this section that you're quoting here is not well quoted. Please take it back. So it's just that I don't know under what circumstances is Tebogo saying that, because Tebogo, they were both investigating and they were quality assuring. So they were the team that was doing quality assurance. So I wouldn't know which reports were issued without them quality assuring, unless they are talking about somebody to quality assure other than the quality assurance team.
Okay, thank you very much, Mr. Tebelo. In your work in that office of editing and correcting the reports, the grammar, as you are saying, did you in any way given an instruction by the PP to change the content of the reports, or to to take out some contents of the report and put something that she would have wanted?
Now, the reports that I will get to look at them, I will either get the reports directly from the executive manager under whose line the report is coming from. And maybe the report would have been submitted to the public protector, but the public protector feels that I need to look at the report to check if the report is okay in terms of grammar, because we believed that the report, when it comes, the quality assurance part was done. But myself, to the extent where I saw that something was not right, I was dealing with the investigators, not dealing with the public protector. So I never got an instruction from the public protector to change a particular report in that fashion. And I don't think that it would have been proper, because in my dealings with the investigation team, if I have something that maybe I have on Tebogo's report, I will discuss it with Tebogo until we agree. Not that I should take it first to the public protector and tell the public protector that I don't agree with Tebogo here. That was never my approach.
Okay, thank you, Mr. Tebelo. Did you in any way see anything wrong with the recommendations where the public protector instructed that the constitution be amended?
Well, as I indicated, the report of the CX, my limitation was on the editorial and on that weekend where Mr. Matlawe did not pitch up. But the report was then finalized, and I can't recall what was in that report and the recommendation that were in that report. Those I wouldn't recall them.
Okay, thank you very much, Mr. Tebelo, for your response. I thought that maybe you did edit or correct whatever, then you might have seen the recommendations where you can make an input on my questions. Chairperson, thank you very much.
Thank you, Honorable Zagude. Before I go to the next person, just to ask all of you members that you, as we go to the next one, please don't compete with repetitions of the questions. Thank you. Before I recognize Honorable Majosi, I see the hand of Advocate Mbofu, because he's not on the list of speakers, but I see your hand.
No, Chairperson, I apologize. No, I must lower it. I was just making it black.
Okay. Thank you. Thank you, Advocate Mbofu. Let your hand remain black. Thank you. I now recognize Honorable Majosi.
No, thank you, Chair. This is me, Honorable Majosi, but can I switch off my video, because I'm experiencing problems with our substation, so I'm not sure in terms of network whether I'll be able to hold on up until I am done, Chairperson.
We have seen you. We will allow you, especially given the fact that we know that you've got that young gift that you must deal with. It's less than the substation. It is that gift. Thank you.
Yeah. No, thank you, Chair. Good afternoon, honorable members. Good afternoon, Mr. Tebele, and all parties involved. No, mine would, I only have a few questions, Mr. Tebele. You said to me when you came into the institution, they used to have a think tank. Is that correct?
Correct, honorable member.
Okay, and then that was, they did away with that, and then you were left with your weekly reports that people would report on, weekly meetings that you would hold of which maybe investigation officers would also report on that. Is that correct?
Let me put it this way. The task team meetings were there when the think tank was there. The weekly meetings that happened, they were already happening in conjunction with a think tank.
So you are agreeing with me when I say after they did away with the think tank, you were only left with the weekly reports and weekly meetings that maybe you would, weekly meetings that you would hold as an institution.
No, Chair, no, honorable member. After the think tank, we still had task team meetings, which were the weekly ones, and we had dashboards, which was monthly. Those were the meetings that the public protector was chairing besides the think tank.
So you had weekly meetings. I'm not asking in terms of oh my God.
He also wants to ask a question, so please be patient. She also wants to ask a question. The young gift. I did tell you.
Yes.
Go ahead. Go ahead.
I'm based on your weekly meetings, let alone your dashboard meetings and so forth, but I'm basically mainly focusing on your weekly meetings that you were having in the institution, and you are saying the PP was part and parcel of those meetings.
Correct, honorable member. The public protector was chairing the weekly meetings. And
then the weekly meetings would be attended by who? I'm asking this because I've mentioned also do investigation officers attend these meetings?
Thanks, honorable member. The office of the public protector, in terms of the private office, they were only offering support to the meetings. The meeting was attended by the quality assurance team and attended by all the executive managers responsible for investigations.
Okay, yes. So meaning that if there were deadlines and maybe there were deadlines that were not met, it's something that you would discuss within the weekly meetings.
Yes, within the weekly meetings, all the investigations or all the Section 7(9)s that were serving during those meetings, they will have an update and they will have a deadline in terms of when do they finalize it, and it will be recorded as such. So those deadlines were monitored during those weekly meetings.
Oh, so the deadlines were monitored during the meetings. So then, which means the public protector would then be informed whether the officers are not yet done with investigations within the cases or whatever processes that would follow after that, which means she would be informed in these meetings about the processes of the cases that would be at hand.
Correct, Honorable Chair. The investigators, the EMs that were attending the meetings were responsible to give updates on the matters that were serving on the weekly task team meeting. And the public protector will be aware of the dates or the deadlines that are given and the product that is supposed to come out of that meeting and when to expect the product.
So when you were asked questions, you said it would not be maybe appropriate for a public protector maybe to raise her voice as much as it's something that you have spoken about in your affidavit. But now I want to ask you, do you think it was appropriate now knowing that the public protector would have information about these cases, and the public protector would get whether the deadlines would be met on time, or people will still need more time on their cases that they are working on to yell on certain cases that you were saying maybe the public protector would raise her voice in a meeting. So do you think these people that have came forward to say this is what they've experienced when they were dealing with cases, and maybe the public protector would raise her voice in meetings because people have not met their deadlines? Don't you think it was inappropriate of her to do so, because already she would have information that a certain case that they're working on maybe cannot meet this deadline, or it can meet this deadline due to the fact that you were meeting weekly and reporting weekly that how far are the cases?
Thanks, Honorable Member, and through you, Chairperson. What was happening during the meetings is we will go through the Section 7(9)s in terms of a particular executive manager, and we will give updates in terms of where is the process, and there will be a date which is given, be it coming from the executive manager or be it coming from the public protector, to say, we are sitting today is the 3rd of August. I'm expecting this output maybe after a month, which is the 3rd of September. When we meet every week, you only report update. But come the deadline, because there will be various deadlines that are given. Those that have promised and the deadlines are passing, that is when they should be indicating what is the held up. So even if the public protector is there, but the deadlines, they remained, we recorded the deadlines, it does not mean that when the public protector was there, the deadlines that gets given, when the days come, then the public protector is not empowered to answer, to ask where is the report. Yes, the public protector could be well aware that this thing is not going to happen from the updates that are being given. But if the deadline was given, we wait for the deadline. And when the deadline comes, we want to see what product do you have. It is not in all cases where voices were raised. I was just talking about instances where voices are raised, but I was not saying that in all the instances where a deadline has not been met, voices were raised. No, it was not, I did not mean it that way.
Okay,
Thanks,
you have answered me. Thank you very much. But maybe one last question. When you came in the institution, you said you found a think tank, the think tank. And maybe after 3 meetings of that, they saw that it's not working, and then they did away with it. In the cases that were mainly maybe on the think tank, I don't want to say maybe all of them, but would you recall maybe how many cases were won in court, or the reports that were given, how accurate were they within the meetings of the think tank? And also maybe you will say that it was the majority of cases that were won or not, or it was the accuracy of the reports that were given there, it was a majority of them or not?
Thanks, Honorable Member, through you, Chair. I think what Honorable Member is asking is the effectiveness of think tank in terms of the quality assurance. And you would want to say so many reports served in think tank, and so many reports went to court, and so many reports were lost. That information I don't have, and I am not sure if we can go back in history to check how many cases served in think tank, sorry, whether they were reviewed or not. and what was the outcome. That information, Honorable Member, I would not have as we speak now. But I understand your question.
All right. So after
Thank you, Honorable Majosi. That was your last, as you indicated.
Okay, Chair. Thanks.
Look after the young gift. Thank you. I now recognize Honorable Mailam.
Thank you, Chairperson. Good afternoon, members, and good afternoon, Mr. Tabele. Mr. Tabele, in your affidavit, you stated that you started work in the private office of the Public Protector on 1 June 2017, and you said to Honorable Dlakude that your role in the CX report was editorial in nature. Can I ask you, were you involved in any way in the review proceedings of the CX/Reserve Bank report?
Thanks, Honorable Member. Through you, Chair. No, I was not involved.
Okay. Mr. Tabele, did you attend any meetings with Stefan Yetso attorneys and Advocate Bum, or with Michael Bull Motswaneng attorneys and Advocate Motomele with regard to the CX report?
No, I never attended any meeting with attorneys on the CX report.
Mr. Tabele, do you have a security clearance?
When I joined, yes, I had.
Has it not been renewed?
It's still with SSA after 5 years of submission.
So what security clearance do you hold, or did you hold back then?
It was confidential. I used to have security clearances in my career.
No problem. In your work at the Office of the Public Protector, have you ever handled or had cause to handle information that would require a security clearance?
I would, let me put it this way. The information in the Public Protector during my time was not classified.
Okay.
So you wouldn't know the information that you have, whether it's confidential, secret, top secret. It was not classified. It's only the employees that needed to go through the vetting, but the institution did not have classification.
So to come back to my question, none of the information you have handled or any work that you have done has in any way been classified in terms of requiring a security clearance?
Yeah, I would say the work in the Public Protector's office, be it information coming to the Public Protector's office was not classified during my stay. I don't know now, but I know that the institution is still implementing classification. So we never had classification in the institution.
Why would you need a classification? Why would you need a clearance? Sorry.
No, that is what the institution wants. People should be cleared.
Were you aware that prior to Advocate Mkhwebane, there was no requirement for a security clearance by members of the Office of the Public Protector?
I'm not aware. I was not there. I don't know. What was the situation? Okay. I really don't know.
Okay. In paragraph 29 of your affidavit, you state, and can we throw it up on the screen? And this is in reference to the Public Protector raising her voice, etc. And you say, this was especially so when those in the employ of the Office of the Public Protector are not doing matters the way the Public Protector wants. What did you mean by that sentence? They're not doing matters in the way the Public Protector wants.
This precisely mean the deadlines that were given, and the deadlines were not adhered to. And then that is when the Public Protector will indicate that you guys, you are basically taking me for granted, because I'm sitting here assisting the process, and you still don't see the need to meet your own deadlines. And that is the essence of my paragraph 29.
Did it include, for example, making specific findings or proposing specific remedial actions?
In the work that I did to support the public protector, I was not sitting in all the meetings that the public protector will have on specific investigations. But to my knowledge, in the meetings that I attended, that would not have included instructions to say, remove this and not remove that. And to the extent that the reports were saving, each and every person would give an input in terms of shaping up the investigation and the report. And that in itself included the public protector, but not specific to say, remove this, remove that. The final report of the public protector will be with the public protector, and the public protector will engage the investigator in terms of what is the content of that information. It is not in all cases where a report will be discussed and I'm present. In those meetings, that is where I recorded what was happening, and the essence of my paragraph was in relation to what would have been agreed to, mostly on the deadlines or on a certain research, and that was not done. And the investigators or the person concerned will be reprimanded during the meeting.
Mr. Tabele, you stated earlier, in paragraph 30, you state investigators had to put more time, which may include not sleeping in an endeavor to complete reports for purposes of meeting deadlines. Would you agree that that's an unreasonable request or requirement of employees?
This is not factual because I did not see an investigator who was not sleeping. But the investigators will say, you know, last night I did not sleep because I was working on this report I needed to finalize. Whether it's reasonable or not, it depends on the circumstances under which the investigator found themselves. If you have 4 years to complete a report and you did not, now suddenly you have a day to complete it. It will call upon you as an investigator to put more time and also to sacrifice maybe your weekends or even your sleep without anybody telling you that don't sleep. The statement that I put there was what I was observing and what I would hear people say. It is not what the public protector said people should not sleep because they must meet deadlines.
Okay. Okay. Would you agree that such behavior, for example, going without sleep, could compromise the quality of the work produced?
It depends. It's not a standalone thing. If the work has not been done in time, everything will happen. And if work has been done in time, there could be time to correct.
That's not the question.
I'm not saying reports that were done in time did not have mistakes. But if you don't do your work in time and you find yourself under pressure, there is an element of having to produce a report, whether it's good or bad. That is
that's not the question I asked you. That's not the question I asked you. I asked you, would you agree that not sleeping or going without sleep could compromise the quality of work? I'm not asking about deadlines. I'm asking you, would you agree that going without sleep can compromise the quality of the work produced?
Thanks, Honorable Member. Yes, it could, because every person has also concentration in terms of timeline. So there is a time where you can't concentrate. It will compromise it.
Thank you. You stated earlier under cross-examination that Advocate Nkobane had the final say on all reports. Does that mean that ultimately the responsibility for the quality of those reports rests with her?
When I said she's responsible for the report, I meant the final report. But the investigation would have been dealt with by somebody else. And in my understanding, when you read the report and you feel comfortable with the report and you sign it, that's the report. But it does not take away the fact that you did not investigate.
Yeah, Mr. Tabele, you're not answering my question.
That is my understanding. All the reports that goes out of the public.
You're not answering my question. My question was, Mr. Tabele, my question was, does that mean that ultimately the responsibility for the report rests with the public protector? You said she had the final say. Does that mean that she is the person who is ultimately responsible for that report, regardless of everyone else? It's her signature on that report.
Yes, she's the last person to okay the report.
Okay. You stated that the quality of reports was not compromised by the changes in the QA process or the increased time pressures. Just a quick question. Are you aware of the CX judgment?
Yes, I'm aware.
And you're aware that the report was based on a discredited intelligence report?
Yes, I read that.
And that report contained remedial action that was considered unconstitutional by the courts?
Yes, I read that.
So do you still believe and stand by your assertion that the quality of reporting did not decline?
The quality of reporting did not decline.
My point is,
are you specifically referring only to that report?
No, I'm not specific. Okay, so I'm using that as an example. I can give you another example. In the Gordon matter, the investigation into violations of the Executive Ethics Code, are you aware of that judgment?
Yes, I'm aware.
And that the court found that the public protector had rewritten or written words into the Executive Ethics Code that weren't there. Are you aware of that?
Yes, I saw that.
Are you aware that she continued arguing that and arguing her position in that matter long after the High Court made a finding? In fact, she argued it all the way up to the Constitutional Court after the High Court had pointed out that she was incorrect in law in that regard.
I'm getting lost, Honorable Member. Are you taking me through the judgments? Are we now?
I'm asking you, are you aware?
Yes, I'm aware.
Okay. So again, do you stand by your assertion that the quality of the reports that were put out under Advocate Nkobane did not decline?
That is a subject of statistics. If the Honorable Member can say there are 100 reports that were issued by the current public protector, and 70% of those reports,
no, Mr.
the courts found them wanting. Because I don't have the statistics, I'm unable to make reference to what you're saying.
Mr. Tabele,
It will be your last take.
with the greatest of respect, you yourself said that the number of reports issued had increased substantially.
Yes.
That's what you said.
Yes.
And now I'm pointing you to two specific reports, and there are others. We can go through them all if you want, but there are others, two specific judgments that identified severe factual or legal problems in the reports themselves. And my question to you is, do you stand by the statement that the quality of reports, noting that there are factual errors and that there are legal errors in the reports, did not decline under Advocate Mkhwebane.
Honorable Member, in a way you are trying to put me in a corner, but I'm going to respond. You can't talk about one report and you would want me to make a statement that the quality of reports declined. How many reports did the courts talk about? And then how many reports are still in good standing? That is all what I'm asking. For me to give an accurate answer without looking at one report, I would need to check how many reports are still in good standing and how many reports have been set aside by the courts. Then I'll be able to say the standard has declined. But currently, I am unable, based on one report or two reports or three reports. It needs to be done in terms of a population of the reports for me to say that I agree with what the courts have said, but I'm unable to say to you that there is a decline in the number of quality reports. What about those that are still in good standing? What do we say about them?
Thank you, Mr. Tebele. Thank you, Honorable Mailam. At that point, we're going to take a tea break for 15 minutes, and we're here at 10 to. Thank you. Now, yeah.
Recording stop. Recording in progress. Recording stopped.
Thanks, Honorable Chair, and through you. The office was profiled, yes, during her time. That one I won't deny. It was profiled during her time to reach a certain degree where people became more aware of the office itself. And I think when the current one came in, through her Vision 2023, she also wanted to profile the office differently. The office was mostly profiled by the Nkandla judgment, which in my view also created more awareness to the public that you can get help from this institution. Hence, I would think that the number of cases that we are receiving is in relation to the profile that was done by the advocate Tuduma Donzel and the Nkandla judgment that the office won.
Yes. So what we're describing is an organization that was changing, a leader that came in and wanted to change the organization's focus. We had an organization that certainly in terms of its customer and external base now was more aware of its services and its products, right? Would you say that the public protector is a team player?
Yes, the public protector is a team player. I don't think that there is anyone in this office who doesn't know the public protector. And she has been participating in most of these meetings, mostly relating to work. I think that is where maybe many people don't like seeing her many times, but she is a team player. She does guide her team in terms of the investigation. Yes, she is strict in terms of what needs to be done. And that one, I won't take away from her. She is very strict and time-bound.
Okay. How many years experience do you have as a senior manager?
I think about 20 years now.
Okay.
I've been a chief director for many years, up to the level where I am.
Okay. How would you describe the public protector's ability to handle negative criticism? Has she ever made a mistake or acted in a way where you needed to offer advice or perhaps confront her with that behavior? How did she react to that?
In the space where I am, I mostly respect authority. And I wouldn't have done that, except maybe if I was just advising on something. But the way I respect authority is I cannot confront my boss. That is how I am. So I never confront my boss. And
so
I think
bad news.
Sorry?
So you don't give bad news. I mean, if you need to differ from your boss, I'm asking, if you needed to differ on a specific opinion, have you not had any differences where you needed to maybe give a different opinion and needed to challenge a specific decision? Have you never been in that position, or is it not your disposition to do so?
No, not with the current public protector. Where I give an opinion, it will be an opinion on something that I think I just need her guidance, but not really relating to the work, because I believe that in terms of the investigation, there are those people that are carrying it out that are better suited to give that type of an opinion. I would rather give the opinion to an investigator than to go give it to the public protector. That is how I would deal with it.
You were part of the meetings where obviously some of the investigators may have had a different opinion or a different view on a specific matter. Do you have any such situation where you saw the public protector having to, absorb a different opinion from staff?
The investigation in itself is a different discipline. People investigate and they come up with certain things. There are situations where I have had the public protector giving inputs into investigations. And even where maybe she might have different opinion in terms of how certain things are. But that is the nature of work, because when people sit together, where they consider these investigations, there are different opinions that are given. And the public protector also does give those particular opinions in those meetings. It's not that if it's a meeting where the investigators are presenting, then the public protector just keeps quiet until the end of the meeting. So I think it's how healthy the environment should be, where opinions get added into the meeting, because as an investigator, you depend on other people to shape up your investigation. That is how I've seen it panning out.
Were you the direct superior of Mr. Neshunzi?
In corporate services, yes, the security fell under my discipline. So he was reporting to me in terms of operations, but Mr. Neshunzi had a direct reporting line to the public protector and the CEO.
So who in leadership informed you of Mr. Neshunzi's move?
It was the accounting officer, that is the CEO, Mr. Mahlangu.
Do you know why it is that you were asked specifically to speak to Mr. Neshunzi?
Because it fell under my portfolio, and if he needed to move, I needed to know about the move. And that is why I was consulted that the leadership would want to shift Mr. Neshunzi from the position that he was to another position for operational reasons.
Yeah, I think I read, I'm not sure, you can correct me, but I read that you said you were not certain why it was that he was moved. You were just told to tell him that he was being moved.
I was told that the leadership would want to move him. And because I was not privy to the report that was given to the leadership, I took what the leadership was saying, and I advised Mr. Neshunzi in terms of the leadership decision that they would want to move you. And I indicated to him that I cannot give you specific reasons because I don't have the reasons. But there is a feeling that considering the position that you are occupying and the investigations that have been currently going on, it will be a better move for you to move away from security.
Okay. I'm not going to expand on that because I don't have time. I would have loved to, but you said in your testimony today, you said, or you referred to an overwhelming demand on investigators. That was your testimony this morning. What measures were put in place to improve individual and organizational performance in light of the increased output demand that was there to eradicate the backlog? So what did leadership, as you refer to it, done to strengthen the organization in light of the change that was introduced by the new PP?
I'm not so honorable member if I get it correct, because the overwhelming work that I was talking about is in relation to the number of cases that people have. I was not addressing the capacity of those people, but the institution does have training that they offer to people. And the training for a while did not kick in because of financial constraints. And currently the institution has made inroads in terms of training with the DOJ College of Justice and the SIU in terms of capacitating our investigators. But that is not in relation to the overwhelming work that I was talking about, because that is just the number of workload that each investigator would have had in a particular time.
Yeah, I think I heard you say that, that because of the
and that will be our last one.
Okay, then I change the chair. Then I will just ask this one question. When you received the Audi letter, have you been counseled before you received the letter?
No, I did not need counseling because I knew what to do. I needed to submit my performance agreement, which was the basis of that Audi letter. So I did not receive any counseling, and I did not reach that stage where I need to be counseled.
Okay, so you just directly, the organization went straight to give you an Audi letter?
No, the organization gave me an Audi letter, and then I responded by giving them what they wanted.
Okay, thank you, Chair.
Thank you. Thank you, Honorable Sukas. I now recognize Honorable Mahlauli.
Thank you very much, Chair. Greetings to Mr. Tebele. Mr. Tebele, in your submission to this committee under oath, you have indicated that you have never seen the public protector or the CEO, Mr. Mahlangu, intimidate or harass employees. Now, under oath, is it your evidence that those who came here and those that are still coming who have made that allegation have misled the public and this committee?
Thanks, Honorable Member. It needs to be recorded that the period that I'm dealing with is the period from June 2017 to October 2018. And the statement that I made the statement in terms of where I was present. I did not make the statement in terms of what other people are saying. It's where I was present. And at this stage, I am not going to say the people that you had were lying, because I was not in the environment where they were when they experienced what they experienced. I only mentioned the situation where myself I was, and I said I never experienced it. So it's not a question of people said that and I'm saying they did not. I'm not countering what people have said. They could have experienced it in their own way, but they did not experience it in my presence.
Thank you. We have heard that senior managers and executives are leaving the employ of the Public Protector SA. Do you think that has weakened the organization? And has the integrity and honor of this office of the Public Protector in any way eroded?
Thanks, Honorable Chair. Honorable Member, the coming and the going of people in an institution, I think it's normal. And people go, other people come. And that is something that is not stopping. And people go for different reasons. I wouldn't know the staff turnover that we are talking about, what would have been the cause of the staff turnover. But as an institution, I think that we want to hold on to the experience that the institution would have built over time. Yes, when people leave, you are bound to lose an experience in that person. But through the recruitment process, you will gain another experience. So that is what I can say. I don't think that I'm in a position to say this would have weakened the institution, because institutions, people resign and others are coming. So that is normal in any institution, irrespective of what type of institution. So to me, the resignations that are happening could be people getting new good offers, getting new places. I don't know the reasons why they would leave, but I have not assessed whether the institution became weak because of what people have, when people have resigned. And I would not have assessed that the institution became stronger when other people were appointed.
Thank you. There was an SMS this morning, a display of exchanges of SMS between the public protector and Ms. Basani Baloyi, which, when you responded to one of the questions, you said you would not know why the public protector would inform Ms. Baloyi to be careful of what she says. And you submitted that you have known the public protector for a very long time and you have good relations. Do you interpret the SMS or the information that the public protector was conveying to Ms. Baloyi? Would you say the public protector is being is a dishonest person to you? And if not, what is your interpretation of that message? Do you think her utterances may have created distrust between you and the COO, Ms. Basani Baloyi? That would be my last question, Chairperson. Thank you.
Thanks, Honorable Member. I would not know under what circumstances the author of the SMS would have said it. And I did not know because Ms. Baloyi Basani never communicated that SMS to me. When I looked at the SMS, I think it's dated 2019. I have been in this institution since that SMS. And I am still here since that SMS. And I've been interacting with the public protector in terms of the work that the CEO's office does. So at no stage did I suspect anything. And even now, as I'm sitting here talking to the committee, the SMS is noted from my side, but there is nothing that I can do on the SMS. And I cannot change because of the SMS, because I don't know under what context and why was it done. So I'm not going to label the author of the SMS in terms of how the author saw me when the SMS was sent. I'm indifferent and I remain who I am and loyal to this institution even after that SMS. So I believe the SMS would have died its time considering when the SMS was done. I had no confrontation from the public protector if she is the author of that SMS relating to the SMS. So I'm indifferent, and how I see her and how I see the institution, it remains the same. I could be disappointed and trying to understand what the SMS meant, but for now, I don't think that it will help me because it's almost 3 years ago or 2 years ago. So if I go to the past, then I won't go forward. Thanks, Honorable Member.
Thank you, Mr. Tebele. I now recognize Honorable Heron.
Thank you, Chairperson. Chairperson, if I may refer to Mr. Tebele's evidence earlier this morning, right at the beginning where he referred to being appointed in June 2017. In his affidavit, it's paragraph 4, where he says, I applied for the above mentioned position in the Office of the Public Protector in the private office. Mr. Tebele, I assume from that paragraph that the position was advertised and you went through a normal recruitment process before you were appointed. Is that correct?
Correct, Honorable Member.
And was the issue of a security clearance part of the recruitment process? Were you, was it part of the advert, or was it part of your contract that you had to have a security clearance? Was your contract conditional on you being granted the appropriate security clearance?
I don't recall, but I don't remember so. And even now, I don't think that it is a condition of employment.
So you said earlier that you did have a security clearance and you're now waiting for a renewal.
When I came to the institution, I had a security clearance that was almost expiring, and I submitted my Z204s as required by the office. And even today, I'm still waiting for SSA.
But you don't regard it as a condition of your employment?
I've never seen it as a condition of employment. Throughout my experience in public service, security clearance was never a condition of employment. It's something that gets required when you are in your job. That is what I know. I don't know if things have changed now. Security clearance is a condition, because if security clearance is a condition, it means you will never appoint until the clearance is done. That is what it means.
Okay, I ask because there was some evidence previously from, I think it was Mr. Samuel, that it would be hearsay evidence that there were some members of staff who were forced to leave because they could not obtain a security clearance.
Well, I'm not aware of those conditions. And maybe there are reasons for that to have applied to those people, but I'm really not aware, so I can't give comment on those. The statement that I'm giving, it's a general statement in terms of my understanding of recruitment in public service, which I have been a member for the longest time. Security clearance, it's always not a condition to employ a person. It becomes a condition when you are inside in terms of access to information, because the purpose of security clearance is to regulate what information can you have access to, not whether you can come to the job place or not. That is my understanding of security clearance. Otherwise, security clearance take long. Institution would not have employed people if security clearance was a condition of employment. And I take it that is how the public protector applies that principle.
And so when you were acting as the executive for, was it corporate services for a while?
Yes.
That would have included the HR function. You were not aware of whether security clearances were a requirement of employment at the public protector's office?
As I'm saying, I have not seen any document where security clearance is a condition of employment in the Office of the Public Protector.
Thank you. Also earlier on, Mr. Tebele, you spoke about when you were in the private office of the Public Protector that you would receive reports, and you said some of them belonged to the Deputy Public Protector and some belonged to the Public Protector. How were the reports, and I think they were investigation reports, so I assume they were, how were the roles sort of separated or divided between the Deputy Public Protector and the Public Protector? Who would handle what kind of matters? How was that managed?
Thanks, Honorable Member. Through you, Chair. I think in my statement, I said the information that was flowing to the private office will be information that will be destined to the Public Protector and information that will be destined to the Public Protector. I did not specifically mention reports. In private office, we get all kinds of information. In terms of which one goes to the Public Protector in terms of investigation, it depends on the delegations that the Public Protector is having with the Deputy Public Protector, which is normally not part where I come in. And during my stay there, the Deputy Public Protector was assisted by an investigator doing certain investigations. But those investigations were not dispersed by the office which I was supporting. They were agreed upon by the executive authorities in terms of which one do you take, which one do you guide. Because remember, the offices were not investigating. It's only the teams that were assisted by the two executive authorities, that you will assist team A, then I'm also assisting team B. How that was done, I don't have a clue.
So if I understand you correctly, there was a delegation of some oversight over investigations to the Deputy Public Protector by the Public Protector.
In my understanding is the work of the Public Protector and the Deputy Public Protector. The Public Protector delegates functions to the Deputy Public Protector. That is how I understand the work to be.
And then just finally, the evidence leaders this morning suggested that we were going to hear some evidence that it was frowned upon, or there was a culture perhaps of fear within the organization around taking annual leave, which you, I think, denied being the case. I mean, you have been there 5 years. Have you taken annual leave in the last 5 years?
Yes, I did. In the case where I did not, it is not because people declined. And I think in my earlier statement, I indicated that leave in general is given for operational reasons. So when you apply, you are saying to somebody, I would want to go on leave, can you please approve it? Which means that person can say no or can say yes. And when they say no, they've got their operational reasons to say leave is denied. But what I did not comment on is the frowning, because I wouldn't understand when you make an application and because frowning is an expression of it's a facial expression, and somebody frowns on, our leave is done automatically on the system. And I don't know if frown upon is the correct word, but when leave is declined, it can be declined for different reasons. And I don't want to comment on those leave that was declined because I was not privy to the reasons why leave was declined. I was merely giving a synopsis that when you apply for leave, you are requesting to go on leave. And if somebody says, your supervisor says, we have got a lot of work, can you please do this before you go on leave? That is always understandable. But how their leave was declined, I wouldn't know. I'm sure they've got evidence that this leave was declined, and then this is the frowning that I got upon me applying for the leave. But I can't speak for those. I was speaking about the leave in terms of my understanding. Yes, myself, I've taken leave, which was approved.
So look, finally, not to over belabor the point, but I mean, I guess every employment contract, no matter where you're employed, has a provision that leave will be taken at the discretion of the employer, always related to operational requirements. So that's not an unusual clause. But I guess by frowning upon the colloquialism is that it was discouraged, or the taking of leave was perhaps discouraged. But you're saying that the application process was an automated or an electronic process for applying.
Yeah, we currently have an automated system where you apply, and in certain circumstances, we do have a manual system, which is a backup. So, because I wouldn't want to comment in terms of the leave that was declined and frowned upon. I was just giving a principle in terms of leave. You apply, yes, the conditions of basic conditions of employment, they indicate that you are entitled to annual leave. But when do you take it becomes operational in terms of how you are allowed to take leave. So I wouldn't know the circumstances that those leave were declined. That is why I'm saying I'm reluctant to talk about it, because I don't have anything. But in terms of principle, every individual needs to go on leave at a certain point, which is allocated on the system.
Okay. Thank you very much, Chair.
Thank you. I now recognize Honorable Ngola.
No, Chair, my questions have been covered. Thank you.
Thank you, Honorable Ngola. I now recognize Honorable Skosana.
No, thank you very much, Honorable Chair, and greetings to everyone. Mr. Tibele, can you hear me?
Honorable Member, I can hear you. Maybe for the record, my surname is Tebele.
I thought that's what I said. I said Mr. Tebele. Maybe my pronunciation might not be that good. Mr. Tebele, is your current position at the same level with your previous one?
Yes, it's the same.
So why did you opt to leave your previous position for this one if they are both at the same level?
Oh, okay. When I left the private office in 2018, that was when the CEO, Mr. Mahlangu, joined the organization. I think he joined in May. And I think after his observations, he felt the need that the corporate services should have a person, because corporate services was big, with about 7 senior managers having all to report to the CEO. And he approached me to say, wouldn't you want to hold the fort in that area, considering your experience from where you're coming from, to assist the organization and also to assist me to manage the institution better. And at that time, the corporate services executive manager was open, and it is still open because the institution could not fill the post due to financial constraints. So they needed somebody who can come and hold the fort in that area. And that is how I was requested to go and act in the area. And when I was acting in the area, the need to continue the work in executive support continued, because my role there, I was managing the dashboards, I was managing exco meetings that were taking place in Mankoth. And my role there was still needed. And they said, you know what, do you mind if you can vacate the post and occupy the post that is vacant in the CEO's office as a matter of principle, but continue in your acting so that the post in private office is freed up and it can be filled. And that is how I moved to the CEO's office, and I remained acting in corporate services until last year when the current CEO came in, and the current CEO said, no, you know what? I'm very much new in this organization. I would really want you to come to the position. And that is how I went to the position.
Okay. What is the actual difference between the think tank and the task team, besides the fact that the think tank was meeting quarterly and the task team was meeting weekly? I'm talking about in terms of their form and operations. What is the actual difference?
Thanks, Honorable Member. I think those organizations, they had their terms of reference, but let me give my understanding in terms of how they differed. Think tank was considering reports that were ready for the public protector to finalize. And that was the organization that was looking at the report, critiquing the report, and almost like giving input into that report. In think tank, we did not have Section 7.9s that would go into think tank for as much as I could remember. Whereas in task team, we were monitoring investigations that are ripe for reporting. Once an investigation reaches a report stage, in a form of a Section 7.9, it will be tabled to task team for monitoring until the report is issued. And within the task team, there were special attention matters which would serve in that committee, and there were EMEA matters which will serve in that committee. And whatever task team was doing was not the work that was done in think tank. Think tank was mostly quality assuring reports, going throughout the report in terms of legislation findings, all the phases of the report, and critiquing the report. And that was not the case in task team. Task team, we were monitoring the reports, and quality assurance team members were monitoring both Section 7.9s and the reports. Then the quality assurance team was the secretariat of think tank, which meant that when reports are ready, then the quality assurance team, through the task team, will table them at think tank for finalization. That is the difference that I can put.
Okay. My next question, did the frequency of task team meetings increase at any stage from weekly to daily?
No, task team meetings, they remained for a week. And when the task team meetings, I think what happened is due to commitments, the public protector could no longer chair the task team. The delegation was done to the CEO, then Mr. Dlamini, if I remember well. And they were still happening weekly. The daily meetings that you're talking about, I'm not aware of the daily meetings which replaced task team during my time in private office.
Okay. The next question, Mr. Tibel. Mr. Kekana gave evidence that Mr. Nyembe was introduced as the political advisor to the PP. Is it true that Mr. Nyembe was the political advisor to the PP? Or that he was introduced as such?
I don't know about the introduction, but what I know is that Mr. Nyembe was advisor to the public protector. But in what capacity, whether political, economic, that I cannot tell. But he was the advisor, so I don't know the introduction that Mr. Gekan is talking about. I'm sure maybe it happened somewhere where I was not there. But I'm aware that Mr. Nyembe was the advisor in the office and was advisor to the public protector.
Okay, my last question, Honorable Chair. Mr. Tibel, was this innovation of the executive authority to assist investigators encapsulated in a policy document in the organization? I think what we spoke about earlier, the issue of the executive authority of being too operational. Is it encapsulated in a policy document of the organization? Thank you, Chair.
Thanks, Honorable Member. I don't think that the management style would be in a policy document. I think executive authorities or leadership, they observe how the institution functions and they determine in terms of how they would want to assist the institution to function better. So it can't be a policy where you regulate even how you can interact with people. I am not aware of this as a policy, and I wouldn't imagine that could be a policy where the public protector, if they want to talk to an investigator, it must be regulated in a policy. I don't think that it is there in the institution.
Thank you, Mr. Tebele. I now recognize Honorable Bondo to briefly interact with you.
Yeah, you know it's not going to be brief, but anyway, Mr. Tebele, did I pronounce it properly?
Yes, Tebele.
Did I pronounce your surname properly? Tebele. Tebele. Is it Tebele or Tebele?
Is Tebele, not Tebele, not Tebele, not Tebele, Tebele. Or Tebele.
Tebele, Mr. Tebele. Tebele, you stated in your evidence in chief that you know Advocate Mkhwebane from your university days, and you and Advocate Mkhwebane continue to keep in touch post your university days. Please confirm if you have a personal relationship with Advocate Mkhwebane.
Thanks, Honorable Chair. Yes, the relationship started during the university days. And if I may put it in context, Advocate Mkhwebane and myself, we were call it study mates. It was 5 of us, including her and other colleagues, assisting each other during those difficult days of discussing certain subjects like your accounting. That is how we knew each other. And after the graduations, we minded to know where some of our colleagues were. And I happened to work around Pretoria, and she happened to work around Pretoria. And the 5 of us, we were around Pretoria. Unfortunately, one passed on in 1998. Then we remained knowing each other. That is how I would say it's a relationship from university days, which just went on even if we were working together, but it's not a personal relationship that I would say every day we were talking. There are years where we could spend 2 years without talking. That is how that relationship was.
Thank you. Can you confirm to this committee, because I got, lost a bit, whether a top secret security clearance is a condition of your continued employment at the Office of the Public Protector, despite the fact that you do not handle classified information in your day-to-day duties?
I think in my response, I said I don't remember security clearance as a condition of my employment. And I don't remember security clearance as a condition of employment in public service. That is what I said. Because I indicated that if that was a condition of employment, it would have meant that institutions could take forever to appoint because they all rely on...
Can I interrupt you there, Mr. Debele? My question is around your continued employment at the Office of the Public Protector. So not a condition of whether you're employed or not, but your continued employment.
I will put it this way. My employment in the Public Protector South Africa is of a permanent nature. That is what my appointment said. And I don't remember where they said, if you don't meet the security clearance in a particular time, your employment will be terminated. That is what I can...
So have you applied for a top secret security clearance since having, assumed employment at the Office of the Public Protector? And if you have done that, why did you do it?
When I was interviewed, I was told that one of the requirements will be for me to submit the Z204 to the institution. And the Z204 I submitted, I think I recall I submitted it during the interviews, even before the appointment. And when I was appointed, I took it that the institution is busy dealing with the vetting together with SSA.
Thank you. My next question is, in paragraph 13 of your affidavit, you stated that Advocate Matlawe, who was at the time charged with leading quality assurance in the private office of the PP, was not happy with the fact that he was reporting to Ms. Molelekwa, who had no legal qualifications. She was the acting chief of staff at the time. You further stated in the process of your cross-examination that the tension between Ms. Molelekwa and Mr. Matlawe started when she started making inputs to investigations and reports. What sort of inputs was she making in relation to investigations and investigative reports rather? What were Ms. Molelekwa's qualifications, given that her original position is that of customer services manager? And do you believe that Mr. Matlawe's unhappiness in this regard was justified or reasonable?
Thanks, Honorable Member. I wouldn't want to deal with the qualification of Ms. Molelekwa in this forum. As I've indicated, that the consternation was due to Mr. Matlawe saying that Ms. Molelekwa is not a lawyer, so why should she ask them about legal issues? And because of the position that Ms. Molelekwa was holding in terms of managing the staff in private office, she needed to go through all the documents that were received in that office. I don't know specifically what is it that she commented, which Matlawe did not like. But her position, we were reporting to her as the chief of staff in that office. And it happened that Mr. Matlawe did not like that because of the qualification. So I wouldn't want to dwell with the qualification of Ms. Molelekwa. It's not my area. Thanks, Honorable Chair.
Right, thank you. In paragraph 14 of your affidavit, you state that due to Mr. Matlawe's failure to attend the quality assurance meeting held over the weekend, he was issued with an Audi letter by Ms. Molelekwa. Who came up with the idea of issuing Audi letters to offending employees? Was the issuing of these letters done in consultation with the legal services or the HR unit? Please explain how these Audi letters would work and how they were phrased. I'm asking this because in terms of our country's labor laws, before an employee can be formally charged, certain corrective steps have to be taken by the employer. You stated that you received an Audi letter for not submitting your own performance agreement that you drafted. Was every employee in the office of the public protector required to draft their own performance agreement? Was this a general practice in the office?
Let me not deal with the specific in terms of who was required to draft the report on behalf of another one. Let me deal with the issue of the Audi letter that was given to Matlawe, because I knew about the Audi letter because Mr. Matlawe told me so. And the Audi letter, I think it needs to be interpreted that it was not given because of the weekend only, because you can't give an Audi letter for somebody who did not pitch up during the weekend. Subsequently, the following week, Mr. Matlawe did not come to work without a reason. And I think that is where the Audi was given. I'm not sure how he saw the Audi, but as a legal person, I think if he knew that the Audi was not correct, he would have contested the Audi. And at this point, I'm not in a position to tell you under what circumstances should an Audi be given, because circumstances, they differ. And I don't know the circumstances that the people were given an Audi letter. I know my circumstance that I was given the Audi letter, and I did not see anything wrong. I complied, and the Audi letter, I think, ran its own time in terms of when it was done. So, Honorable Member, I cannot assist in terms of what the labor laws are saying in terms of giving people Audis. But I think each case should be treated in its own merit and see if those Audis that would have been given were not valid under the current labor laws or the then labor laws. Thank you, Honorable Member.
In paragraph 32 of your affidavit, you state that in your view, Advocate Mkhwebani's predecessor, and I assume you're referring to Advocate Madonsela in this instance, produced far fewer reports than Advocate Mkhwebani. Your evidence in this respect gives the impression or seems to suggest that Advocate Mkhwebani was fixated on the quantity of the reports produced by the Office of the Public Protector rather than on the quality of these reports. We heard evidence that was given by Mr. Samuels that at some stage or another, investigators were restricted when it came to traveling and official vehicles were grounded, and as such, they were restricted to conducting desktop investigations and could not, for example, conduct inspections in locals. However, isn't quality more important than quantity at an important and constitutional institution such as the Office of the Public Protector? Hence, some of these reports being taken on judicial review and the manner in which some of these investigations were conducted being called into question in some of these court judgments.
Thanks, Honorable Member. You have raised a lot of issues, but let me deal with the statement on 32. I made the statement in observation of the number of reports that would have been issued prior to the current public protector. And I did not make the statement in terms of the quality that the reports were carrying vis-a-vis the quality that the predecessors' reports were carrying, because that should be a mathematical calculation in terms of how many reports did Advocate Mkhwebane issue and how many of those reports were set aside and on what grounds. Was it merits? Was it technicality? And how many reports did the predecessor, even if I'm reluctant to talk about that because I was not comparing. I was comparing performance in terms of what I've observed to say, if you had the same number of people, you issued 20, 25 reports, and during those years, the reports maybe were not even yet binding, so they could not even be tested. I'm not saying they were not tested or they were not binding during that time. We will have to check the reports that were issued after Nkandla. How many of them were issued under Nkandla when the remedial actions were binding? And out of those reports, how many of the remedial actions are still standing? And come to the period of the current and compare how many reports did she issue in each and every financial year and how many of them are under review, how many of them have been set aside, and come to a conclusion that the production of the many reports led to the quality being dropped. I think at this stage, we might be speculating without those numbers. Thanks, Honorable Member.
That will be your last point.
Is this my last question?
Yes, yes.
All right. In paragraph 38 of your affidavit, you concede that there was an increase in the litigation involving the Office of the Public Protector, and you attribute this increase in the litigation involving the Office of the Public Protector to the approach taken by the courts that effectively rendered the remedial action of the Public Protector binding. Are you saying that prior to the courts making this pronouncement, the remedial action of the Public Protector was not binding? Hasn't the remedial action been binding? And what effectively happened in the Nkandla judgment was that the court clarified the binding nature of this remedial action.
Thanks, Honorable Member. Before Nkandla, I'm not aware of a situation where the remedial action of the Public Protector were held binding and the institutions were bound by the reports. I am not aware of it. And that is why I made the assertion that because of the binding nature of the remedial action, also the litigation in the institution went up. I might be wrong, but I think before the Nkandla judgment, you could ignore remedial action and nothing will happen. That is what I think happened during that time. I'm not aware that the remedial actions were binding. The Nkandla judgment only confirmed that they were binding. I thought the Nkandla judgment was the first to say remedial actions of the Public Protector cannot be ignored. And if you would want to challenge it, you must go to court to challenge the remedial action. Other than before, the institution, I think, was operating almost as an ombudsman, where you make recommendations, whether they get taken or whether they follow them or not. It's a different thing altogether. I might be wrong, but that is my understanding of the situation. And hence, my paragraph that you see there in terms of the analysis that we made. Since the Nganta judgment, we have seen many reports being reviewed. And our understanding is because you cannot ignore them, you needed to go to court and deal with the situation. I might be wrong in my understanding.
Thank you, Mr.
That is my analysis.
Yes, you have covered the point. Honorable Mautu.
Thank you very much, Chair. Greetings to Mr. Tebele. Mr. Tebele, earlier on you spoke about the backlog at the office of the PP. Now, when the backlog clearing initiative started, was there ever a conversation about how poorly the PP's office is funded in your knowledge? And if so, what were the mitigating measures that the office took to try to overcome that?
Thanks, Honorable Member. My response to your question may not be the same as how you have phrased it. The challenges within the institution in terms of budget constraints, when I came to the institution, the constraints were there. I would even remember that I think the public protector and then the then CEO had presented to National Treasury in terms of how they think the institution should be funded. And if my memory serves well, the institution was getting about 264. So the constraints financially, they have always been there. But I'm not sure whether I can marry the constraints, the financial constraints, to the output of the institution, except to say, due to those financial constraints, the institution could not appoint more investigators because we had a lot of positions that were not funded in the structure. And as such, I think the institution could not get to the investigations that they needed to with the workforce that they had during that time. But I'm not sure whether the funding itself alone could have led to the institution not being able to deal with the backlog that they had. That analysis I don't have.
Okay, thank you. Let's move on to some of the executive managers who would carry out investigations or were overseeing the investigations. Was it not beneficial for the PP to know which investigator is doing what and where each investigation was, meaning how far? And in your knowledge, is there any law that prevents the PP from doing that, from checking progress and finding out what's happening with the investigations and what's on, and so on and so forth?
Thanks, Honorable Member. I think the question was asked before, but I think I will respond to it. In terms of operations, I don't seem to know of any law that really prescribes that if you have this hierarchy of responsibilities, you cannot jump the other to the other one. So in terms of my interaction with the unit, the public protector has always interacted with every investigator that was investigating a matter that a public protector needed an update on, including the executive managers. And I think that is just a management style, which I don't think that it can be recorded in a code that you cannot do this, you cannot do that. I think it's different in styles. If you feel that you want to go down to the grassroots, which maybe public protector believe that let me go to the grassroots in terms of the people that are working in my area to understand, I think it's a prerogative to do that. And I don't think that there is anyone who can say, no, you are not allowed in terms of any rule book. Because investigation in itself is a technical area. And one person alone may not have all the knowledge that the type of investigation is needed. Because you get labor relations, you get procurement issues, you get complicated matters. So in any given point, you need somebody to assist you. So should you have a rule where you say this person should not interfere here, I think you may find it difficult to run such an institution. So I believe that the public protector went down to understand and from there to make an observation, and maybe it's through the observation that she would initiate certain improvements in terms of how the institution functions. Thanks, Honorable Member, through you, Chairperson.
No, thanks. And then earlier on, you also testified about the weekly meetings that public protector used to chair, trying to get a sense of what's going on in different departments and how far the cases are. Now and then she would find some managers who are not delivering according to the agreed deadlines, which just keeps on shifting the goalpost on their own set deadlines. Now the question is, how are she supposed to deal with such issues? And is it not considered corruption for people to just get paid and keep on pushing goalposts and not bringing back the deliverables?
Thanks, Honorable Chair. I'm not sure whether corruption will be the right word. I lack a better word for it, but you are talking about a situation where somebody is employed to investigate and the person is not being productive. I'm sure that is what you're dealing with. But I wouldn't really see it as corruption, because corruption has a different meaning to how you are describing it. Yes, there are situations where in the monitoring, certain deadlines could not be met. There are situations where deadlines were met, and there were different actions that would have been taken in order to correct that, or even just to say, give a verbal warning to say, you know what, next time, please don't force us into this environment. But I wouldn't really say it's corruption, because there will be an element of what those people would have done in the caseload that they have. They may not have done all according to the standard that is set by the public protector, but I'm falling short to can call that corruption. Maybe is short of incapacity. I think it's incapacity more than corruption. Thanks, Honorable Chair.
Yeah, I think it's corruption, but we can debate that some other time. Now, also earlier on, you detailed the process of the report flowing from investigators to executive managers, quality assurance, and finally to the PP's office. How easy or difficult do you think it is for the PP to change the report after it has gone through the entire value chain with possibly the necessary signatures attached to it? Is it easy or is it difficult for her to just change the report?
That I really wouldn't know in terms of the easy part or the difficult part. But I would imagine that where the public protector has a different view in terms of how a report has been presented, she has the right to comment in terms of her view, in terms of the investigation. But I wouldn't say in her doing that, she will be faced with a situation of changing reports alone, doing all these things alone. I'm not sure if that is what she will do. But reports, when they go through the value chain, immediately they pass the last person in the quality assurance and it goes to the public protector. It does not mean that that report can be issued as it is. The public protector has to satisfy herself that the report is in terms of the standard that I would want to issue it. And once that is reached, then she will issue the report. And I'm sure if that report is not satisfactory to her, it will be communicated back. But whether it's difficult to change it or not to change it, I really wouldn't want to comment on that aspect.
Okay, I'll take that. Now, can you describe for us the leadership style of Advocate Mkhwebane and what's your view about it? Would you say you are happy with her leadership style or not?
I would really would have wanted to stay away from that observation. I've already indicated that my observation to how she manages the work is dedication, paying attention to details, paying attention to timelines, eager to make outputs. But from where I'm sitting, I will be wrong to make an assessment on the work and the management style of a public protector. That will be wrong.
Okay, and maybe to assist the committee, what was done in a think tank which was different from the weekly meetings?
Yeah, I've already explained it. A think tank was considering reports that were at the final stage that needed the public protector to attest, because the way the process worked is think tank, the feeder to think tank was the quality assurance, which was headed by Mr. Matlabu. As such, Mr. Matlabu was the secretariat to think tank. When the quality assurance is done with a report, then that report will go and serve in think tank to get more inputs from the think tank members. That one was different to the weekly meetings that we were having. In the weekly meetings, we were considering reports, investigations that were at Section 79 stage, and also those that were at the report writing stage. Then when we were done in task team on the weekly meetings, then those reports will go and serve at the think tank. That is where the difference was. Think tank was the last quality assurer before the report goes to the PP. But remember, think tank also, the PP was a participant to the think tank process.
Okay, and we're talking about Advocate Mkhwebane here, who received 2 clean audits 25 years later, and who issued 412 reports that were finalized, and more than 58,000 out of the 60,000 plus reports. Now, do you think the attacks and the negative criticism towards her is justified by the media and the Democratic Alliance?
Thanks, Honorable Member. I think you wouldn't punish me for not making those political comments, except to talk about the performance that is there that you have alluded to. Yes, I don't want to get into the committee work. If that is the performance that you have alluded to, let that performance speak for itself for those that will be considering the evidence. I would want to move away from it. And I was also reluctant to give testimony to a motion that is political. So for now, I'm fine with what I said, and I don't want to enter the political terrain because it may not be my space. The work of the public protector, I think, would be there for people to see. How they comment, it's a different thing altogether because people comment the way they want to comment. I've given my view in terms of my observations and the experiences that I had in the office. And I'm sure my view will differ with other views. I think I will want to leave it at that, Honorable Chair, if you don't mind. Let me not get into the politics of the process.
Okay, and that's fine.
That will be your last question.
Okay, Chair. So earlier on, I'll club the two questions together then, Chair. You testified about having received an Audi letter for not submitting your KPIs. Did you regard that as harassment? And would you equate raising your voice, in inverted commas, to harassment?
I did not regard it as harassment because it was done in the normal course of business. And people's voices, they differ depending on circumstances. Sometimes people, they talk softer. And when certain circumstances change, then they raise their voices. So that is human nature. I wouldn't put that and connotate it to harassment. There are people that are generally loud, but they are not harassing. There are people that could be slow in talking, but their words could penetrate deeper. So let me not get into the interpretation of a voice in terms of it being a harassment. I'm sure harassment has a clear definition, and something that would be regarded as harassment should fall within the definitions that are there in terms of harassment. Thank you, Honorable Member. I would leave at that.
Chair, can you allow me, please? It's not a question to the witness, just something to put on record. If you allow me, Chair, please.
It's called smuggling. You can do it.
Okay, let me smuggle, Chair. It will take me less than a minute. Chair, we're going to submit a complaint about the conduct of the evidence leaders for ambushing a witness with some gossip SMSs that came through this morning before testifying. So I just wanted to put that on record that we feel very, very strongly that it is wrong. More so that it was sent to the PP's office, or rather advocate, last night, and the witness never received it, and he only received it a few minutes before the meeting started. So we will be sending the complaint to you, Chairperson. Thank you very much.
Thank you, Honorable Member. Your intention is noted after being smuggled. Thank you. I now recognize Honorable Begizo Ngos.
Thank you, Chairperson. Mr. Tebele, good afternoon.
Good afternoon, Honorable Member.
Yeah, Mr. Tebele, you testified about the think tank. I just want to check, did Mr. Mahlangu, the CEO, attend think tanks? What was his participation and what was his input?
From my recollection, think tank happened around 2017. And Mr. Mahlangu, when he joined, I don't remember, we did not have think tank. If my memory serves me well, he joined at the time when we discontinued, or the office was no longer participating in think tank. So he wouldn't have been part of think tank.
Okay.
It was before his time.
Thank you. You said you continually refer to yourself as a lawyer when other things are said. I just want to check with you then. In not doing the editorial work on reports, in other words, putting commas, full stops, indenting, etc. When you come across a paragraph that is blatantly against the law, Do you ignore that and proceed to submit?
Thanks, honorable member. In my previous presentation, I indicated that when I went through the reports, where I found that something is not readable, or maybe a lack of a better word does not make sense, I would go to the investigator. I wouldn't take the report to the public protector. I would go to the investigator and say this is not reading well. And if the investigator agrees with what I'm saying, then the investigator will make amends. That has happened in many instances that I've been in the office. So I wouldn't leave it the way it was, but I will engage the investigator so that I don't just impose my input into the investigation. But that I did without going to the public protector, because I thought I should deal with the investigator so that they can understand my point. Thanks.
I'm saying when something that when you're editing a document and there's something unlawful in the report, do you intend put a comma and then submit it as is? I'm not talking about readability or not appearing well.
I wouldn't understand the unlawfulness of something in a report because how will something be unlawful in a report? I don't understand.
If I make a recommendation that is against the law, that is unconstitutional in a report, and you as a lawyer, you see it, that this is blatantly unconstitutional, do you proceed to submit the report as is? That's the point.
I'm sure, honorable member, you are talking about a situation where the court would have rendered something unconstitutional. Before that time, I may not see it as unconstitutional because maybe I'm not a constitutional expert. Because what you are raising something that you can only discover on interpretation in another court, in a court of law. But when you do investigation, you do investigation based on the facts. And when you provide a recommendation, normally a recommendation is either you take it or you leave it. And I wouldn't understand what will be the interpretation before the court make a pronouncement. So I'm really not understanding the angle from which you would want to raise the question.
There's no angle. I'm very straight. I'm saying when there is an unlawful recommendation in a report, do you submit as is? If you can't answer it, you say no, and then we'll proceed.
Well, I've never come across an unlawful recommendation in the reports that I've gone through.
And you did quality assurance on all reports, CIX, etc., etc.
I said CIX, I did editorial because when I came to the institution, the CIX report and the investigation were all done. We were just assisting to check if the typos are correct. That is what I've given.
There was a very big typo in CIX in that the public protector suggested that the constitution should be amended to change the mandate of the Reserve Bank. That was a very big typo. But anyway, let's proceed. You also say that there are standard operating procedures in the organization. I would like you to provide the committee with those SOPs, including the timelines at receipt, progress, interim, final of all the reports. Remember, you said we did you called it I just want to read here. You called it a age analysis report. May you please provide that to the chair and the committee. Thank you very much. Thank you, Chair. I'm done.
Did you get
Honorable Chair,
Mr. Tebele?
do you expect a response in terms of the request that is being made to me in terms of standard operating procedures of the institution, which the executive authority should give? Because sitting here, I know that there are standard operating procedures, they are a public document. But I think the honorable member is also saying to me, I must also give age analysis. I don't know whether the age analysis is at the time I was in private office, or is it talking about the age analysis of cases as of now? I just need that clarity.
I think, Chair, I think you can provide both. In fact, it will help us to make a comparison at the time that you were there and now. And the standard operating procedures, Chair, you can ask the institution to provide. Thank you, Chair.
Okay, thank you for that clarity. Just before I proceed, I see the hand of Advocate Mpofu.
No, thank you, Chairperson. Yeah. Well, I think the issue of the standard operating procedures can be attended to by the evidence leaders. I think they are part of the documents anyway. That is not what I was rising on. I was just objecting to that honorable member misleading the witness. There's no typo in the CX report. So it must not be put like that. If it's an attempt at sarcasm, then it must be explained, because not all of us find it sarcastic. So, but as a matter of fact, unless if there's a typo that we're going to be referred to, there's no typo in that report. So the record must not reflect something which is false.
Thank you, Honorable Advocate Mpofu. Advocate Bauer?
I simply wanted to say that the standard operating procedures are in the bundle, and we'll get the secretary to direct the member to where precisely it is. Okay. The other documentation to which is requested, we don't have, but I'm sure we can, assistance of Mr. DeBelle.
Okay. Thank you. Thank you. I now recognize Honorable King.
Thank you, Chairperson. So, Chairperson, please indulge me if I can switch off my camera, which is experiencing some load shedding.
Well, since we're welcoming you, I've been looking for you.
Yes.
Go ahead.
Good evening, everyone, and good evening, Mr. Tebele, and thank you once again for availing yourself for questions in this committee. So I'm going to start off by paragraph 32 in your affidavit. It was previously mentioned that you said, in my view, her predecessor produced far fewer reports given the number of investigators in the OPP. And you did allude to the fact that you draw conclusions from observations. I just wanted to find out, was the observations made from the closeout report of the previous public protector, or was it made from comments in the office made by colleagues?
Thanks, Honorable Member, through you, Chair. The annual reports of the institution will always indicate the number of reports that would have been produced in a particular year, to the extent that the number of reports were a target. That is where the information can mostly be deduced from. And that is the comparison that I was talking about in terms of the number of reports, without looking at anything else but the number of reports year on year. That is the comparison that I was looking at. And to say, looking at the previous financial years, this is what the institution would have dealt with. Not categorizing them in terms of closed reports. I'm sure that exercise, to the extent that the information is available, can also be done for comparative purposes. In terms of the previous, I'm not sure if the information is available, but I was talking about what the institution will always regard as formal reports. But I'm sure drilling down to the annual reports, such information could be available in those annual reports. But my comparison was based on what we would call formal reports.
Okay, thank you. Then also on paragraph 32 still, you then stated, as I recall, roughly 160 investigators had, during the financial period prior to the current PP taking office, produced about 20 to 25 reports. Okay, can you see that?
Yes.
So I just want to find out, was the 20 to 25 reports over the remainder of the period of Advocate Madonsela's term in office, or was it just purely on a monthly basis?
Thanks, Honorable Member. I was not there during the time of Advocate Madonsela, so I wouldn't know on a month-to-month basis. And also, if you read the statement, I've qualified it in brackets to say, I have not confirmed these numbers and don't claim them to be exact. But what I know is that currently the reports that have been produced are more than 20 to 25, if 25 is the number, and is based on what could be in an annual report, and is not based on what is done on a month-to-month basis, because I was not there. I don't know how to get the month-to-month reports. I can only rely on an annual report and make observations. Thanks, Honorable Chair, Honorable Member.
Okay, thanks, Honorable Mr. Tebele. Also on paragraph 45 in your affidavit, you actually state the public protector made it clear that she did not want to leave this office with the backlog for any successor to have to deal with, and at the very least, matters preceding 2020 had to be finalized. So if I were to read into that, and I know in a previous statement in your affidavit, you also claimed that the public protector needed these backlogs to be cleared by September 2021. Would that not provide a strenuous work environment, especially since you also mentioned the public protector became agitated at times, would raise a voice? Was it not clearly then to reach the deadline of September 2021 to clear the backlogs?
Thanks, Honorable Member. The date of 2021, September, was specific for certain reports that would have aged on a particular period. Aging in terms of complaints happens every day. When a day passes, another report becomes 4 years and 4 and so the clustering of those reports into the date of September, it was referring only to those particular reports. But aging of report never stops. But from what I could get in the meetings that I attended and how she was expressing her wish was that by the time my period ends, let me at least leave complaints that could be 2019, 2020. At least they will still be within the timelines. It's basically saying I wouldn't have wanted to leave investigations that have aged too much to the extent that the one that is coming has to deal with what I should have dealt with. That is what I was expressing in here. But aging of reports, or no, aging of investigations and complaints, it happens all the time. If today we can go and do the age analysis, you will get a different scenario. But that one was a project for cases to be finalized by 2021. if you do it now, you'll still get others that have run beyond their age in terms of our standards. Thanks, Honorable Chair.
Okay, I hear what you're saying, Mr. Tebele, but I just need to find out as well, for investigators to ensure that they meet the deadline, how many cases are then assigned to an investigator on average to clear? I know you talk about the age analysis, you previously mentioned 5 years. So is it realistic that most cases can be completed within a period of 5 years?
Let me answer it in two parts. In terms of our standards, I don't remember seeing where the standard says a case must be finalized in 5 years. I think we go to 24, I'm not sure, 36, but we don't have 5 years. And as such, cases, as I said, they age all the time, which means the investigators, in terms of how they prioritize the investigation, they also need to take care of those cases that they have received long ago. I think in terms of their investigation style and methodology. But I wouldn't comment on the fairness or the unfairness of expecting the investigators to finalize cases within a certain period without looking at when the cases were received by the institution and when the complaint was allocated to the investigator, because you can't do that without looking at those timelines. And in this case, the investigators, they have their own workload. And I may not know, as we speak now, what is the fraction of the case load per investigator, which will differ because those case loads, they get allocated in terms of how they get classified, your early resolutions, your complex matters. So they've got classification and they've got timelines. And sitting here, I can't tell you what is the average case load per investigator, because we need to go through each and every investigator and check the caseload. The average is easy to get upon calculation because you simply take the cases that the institution have vis-a-vis the number of investigators, and it will give you the average. But that is not the picture because cases get allocated in terms of their complexity.
Okay, I hear what you say, Mr. Tebele. Then earlier on, you also mentioned that the public protector advocates for people who normally render complaints to our office. You also mentioned that if it wasn't for Advocate Tuliba Donsela, and especially some of the cases she dealt with, people then became aware of the work of the public protector, hence you've received more of these cases. So is it then realistic to say that the reduction of the clinics, awareness clinics of the work of the public protector could also have an impact in terms of how you reach people? Can it then have an impact, or can we sufficiently say that Advocate Mqobane actually advocates to the complaints of the people with the reduction of the clinics, awareness clinics of the public protector?
Thanks, Honorable Member. I don't know specifics in terms of the reductions, but I think it was an approach that we can do better when we deal with districts. And I'm not sure if you are saying the reduction of the clinics could have contributed to the outreach that the public protector would want to do, because the public protector still on her own had the roadshows that we continue to have. And the consideration in terms of the outreach clinics I'm sure it was also dealt with in terms of the cost that the institution was facing at that time. I don't think that it was dealt in terms of trying to reduce the access that is propagated in Vision 2023. Because I don't find the relationship between the reduction of the clinics to the reaching of the grassroots in the question that you are mentioning. For me, those two are not related because there are many ways in which the office is trying to reach the people through community radio stations. Those outreach clinics is part of one of the issues, the ways in which the public protector tries to go to the public, but it is not the only one. Because radio stations also, they perform that function, and she very often go to community radio stations and talk about the work of the office. I think there is more to do on outreach than only focusing on the reduction of the number of clinics. Thanks, Honorable Chair.
Okay, my last question would then be...
It is definitely your last one.
Yes, definitely. The public protector was assumed office in October 2016. 8 months later, in June 2017, you assumed office. So, Ken, according to HR processes in the public protector domain, who is the final person to sign off on the appointment of somebody taking office? And I'm referring now to the office in the private office where you were situated. So that's basically the last question.
Thanks, Honorable Chair. I was not in the institution at the time my recruitment started, and I don't want to claim to know how my recruitment was handled. I would want to move away from that part, and maybe HR is the one that could answer if my recruitment is the one that would be questioned. Thanks, Honorable Chair.
Thank you, Mr. Tebele. I now recognize Honorable Maneli.
Thank you, Honorable Chair, and greetings to Mr. Tebele. Mr. Tebele, I'll just take a few questions. I'll make reference to paragraphs without reading the paragraph, just for you to understand that I'm referring to that in particular. If I were to start with the first question, with regard to paragraph 14 of your affidavit, did the absence of Advocate Matlawe render the report to have not followed the quality assurance standards, or it was immaterial at that stage of the report?
Thanks, Honorable Member. I wouldn't understand when you say in the absence of Advocate Matlawe. Are you saying during the time that Advocate Matlawe would have left? Or are you saying that during the time that the quality assurance unit was moved away from the private office?
Thank you, Chair. I would have requested that I'll refer to a paragraph. That paragraph 14 I'm referring to talks to the CIX report, where you indicate that Advocate Matlawe would have not acceded to the request in that weekend, and therefore the public protector proceeded with the other officials that were present. Now, the question I'm asking is in relation to paragraph 14, which is to the CIX report. All I'm asking is, his absence or having not acceded to that request, did that render the report to have not followed the quality assurance standard, or it was immaterial at that stage of the report?
The report was already in quality assurance. I'm not just sure whether Matlawe at that stage had not seen the report. The meeting that he could not attend, the report was already there. It was just to finalize the report. So his absence, I wouldn't know what it would have done to the report had he been there, because I would not be knowing his views. But the quality assurance was already done. They were at the final stages of quality assuring the report in the presence of the public protector. Because before that meeting, there was another meeting where he was available when the report was being considered, but the work could not be finalized at that time. So the request was to come on another day to finalize the report. But I wouldn't know whether his presence would have changed the report. But the quality assurance would have been dealt with because Utebo Gegana was part of the quality assurance unit as much as Matlawe was heading the unit. So Matlawe was not alone. There were other quality assurance officials who attended the meeting in Matlawe's absence.
So would you say, thank you, Chair, would you say then at that stage of the report, his absence would have been immaterial in terms of quality assurance?
I would take an indifferent view because I wouldn't know if he was there, what type of input was he going to make? So I can't speculate. For me, it would have been indifferent. I will have an indifferent view. Whether he is there or not, I wouldn't know in terms of whatever quality that he would have brought in, that the report would have lacked if the report lacked any quality. But to me, the report had the quality, and I want to believe that he was going to be there also to make input. But I can't speculate in terms of what type of input for me to arrive at whether was it going to be material or immaterial, because you can't base this on an individual when there are other people.
On paragraph 37, Chair, through you, as I said, I won't read the paragraph, just 2 points on that paragraph. In this paragraph 37, are you demonstrating that the PP took personal responsibility and accountability for the reports coming out of an office for public consumption?
Without this paragraph, the public protector is the final person in terms of deciding on the release of a report. So I would think that the public protector would have considered everything when she finally decides that the report is ready for me to issue. That I think will go with the work. More here, I was simply expressing my view in terms of having seen the public protector reading reports, not considering a report in terms of its finality. My statement was talking about, I'm aware that the public protector does read the reports. But what you are asking if the public protector would have satisfied herself when the report becomes final, which in my view, I think that she would, because I wouldn't see the reason why she would not satisfy herself and she would still release the report. I wouldn't see the reason why.
Still on paragraph 37, the sending back of reports that were not in order or in line with the standards, did it also imply that corrections included a relook at findings and remedial actions that investigators would have presented?
Inputs on reports cut across every aspect of the report. You can't be specific in terms of where to make inputs. There will be somebody who will say, can you please check the findings and see if these findings are correct. And somebody can check the remedial actions. So all people that are responsible to look at a particular report before the public protector is issuing or considering the report, they must look at all the phases of the report without choosing which area would they want to look at. And the remedial actions and the findings is part of the report and is part of the areas where people that are making commentary onto the reports, they will also make a report. There is no portion of the report that when it's considered, this one cannot be considered when others are considered. I've never come across such a situation.
Thank you, Chair. Paragraph 40.
Just pause, Honorable Maneli, just pause. Advocate Maris.
Advocate Mkwebane's legal team have indicated that they've just been kicked out of the platform.
Then they must come back.
I don't know if the problem is on their side or on our side.
It's not on our side. Can somebody check if they joining? Just a pause, Honorable Maneli. Are they in the waiting room? Hello? Not yet.
They are trying to reconnect.
Yes, but they are not in the waiting room. Do you want to call them? Advocate Mkwabane, are you on the platform?
Yes, Chairperson, we are here. I think our network challenge, but we are listening. We can proceed. Thank you for the indulgence.
Thank you. Thank you. We'll proceed, Honorable Maneli, after that pause.
Thank you, Honorable Chair. Mr. Debele, as I said, I'm referring to paragraph 40 now. In the review and consideration of proactive ways to improve matters that you referred to, did this include exercising the discretion on whether to litigate or not to litigate.
Is that paragraph 40, Honorable Member?
Yes. We talk about court judgments, and therefore there will be teams that review and so on. Checking if we are in the same.
The paragraph that you are alluding to is the training that is part of the institution, where the public protector has dedicated certain officials within the unit that after each and every judgment, they must analyze the judgment and have workshops with the investigation team and also everybody else, because judgments sometimes they just affect staff in general, so that they can understand and get an interpretation of those judgments, and also the lessons that are learned from those judgments, which should assist the institution in terms of improving in terms of their legal interpretation. Because those lessons, there will be areas where those lessons, the institution can use them against. It was not on the basis of indicating whether you want to litigate or not litigate. It's court judgments which are passed already. The institution make analysis and they publish those analyses, and there are also staff meetings where these lessons they are articulated so that the people in the office could have the knowledge why the work that they would have done would have gone the way it has gone in terms of costs. That is the essence of this paragraph.
Having explained that, Chair, in your understanding, having been in the institution, whose discretion then is that to make that final decision, especially as it relates to litigation, whether to litigate or not?
The litigation is done as a strategy from legal service, and they consult the public protector in terms of their view, in terms of certain matters, and a decision gets taken in terms of how the institution should approach the matter, whether the matter will be opposed, not opposed. It's what is coming out of the strategy that legal services would have written to the executive authority relating to a matter that is being reviewed.
Through your Chair, because the question I'm asking is specific. I guess the legal would advise, and that's why I've asked about the final decision to either go this route or that route, whether it rests then with the legal advice or it is a matter that the PP would have to sign off or not sign off.
Yeah, I'm sure the question also has a way of looking at the current. And I wouldn't want to deal with the current. I would want to deal with during my time. And the current, I think, can be dealt with by legal services in terms of what is happening currently. We would take decisions in terms of which matters and how decisions are taken. I was basically indicating how the office of the public protector get advised in terms of matters that are on review. I wouldn't know the current, what is currently happening.
Okay, thanks, Chair. May I then proceed to the next question? Just in trying to push, I want to understand this, in trying to push performance with eyes to 2023, you referred to clearing backlogs and all that. Did the employer took into account the conditions of workers, or that didn't matter?
I'm sure when you look at the workload that you have, you should also look at the conditions that are available. I don't want to speak for the public protector. I'm sure the public protector is best suited to indicate that. But to me, when you have a caseload which you don't have control over, because the institution is the recipient of complaints, we don't choose which one should come, which one should not come. So at the end, whatever you have and you need to investigate, you will have to investigate. Under whatever conditions, you will have to investigate, because if you receive 100 complaints per day, your resources remains the same. And what do? Shouldn't you allocate to the very same resources that are constrained? I'm sure you will do that. I don't want to speak on behalf of the public protector, because that is what the public protector will consider. But I'm just putting in facts in terms of my understanding of the question that you are raising. Thanks.
Paragraph 18 to 20 under C, those would be my last questions, Chair. Can you confirm if no wrongdoing was found on your part or Mr. Neshunzi after that investigation that led to confiscation of laptops?
If more, I didn't get the question.
Can you confirm if no wrongdoing was found on your part or Mr. Neshunzi after that investigation that led to confiscation of laptops? And I'm referring to 18 to 20 under C, where you talked about leaking of information.
Thanks, Honorable Member. Through you, Chair. In my previous engagement, I indicated that I did not see the outcome of the investigation in terms of the report itself. What the report contained, I don't know. I only indicated that I was approached by the accounting officer, Mr. Masangu, in terms of moving Mr. Neshunzi to another section. And in terms of myself, nothing, I can't say nothing was found, but let me put it this way. Out of that investigation, I was not pursued for anything. So I would take it that nothing was found on my laptop, because up to this stage, I was never dealt with in terms of the outcome of the investigation. But I did not see the report, so I don't want to mislead the Honorable Member.
No, thanks, Chair. On that.
Thank you.
18 to 20. There's clarity there about Mr. Kekana. I will take it that you may have also not seen that report, so I would not pursue then that question further, which you have put. May I then check, Chair, maybe as I said, this would be the last question. Did you bring to the attention of the leadership of the institution that Mr. Neshunzi was unhappy with the movement from security to CSM without reasons, as the institution would have still expected high performance from him? Thank you, Chair. That's the last question.
Thanks, Honorable Chair and Honorable Member. My scope was to communicate and consult Mr. Neshunzi in terms of how he felt. It's something that I would say he wouldn't have accepted it if maybe continuously he felt he was being prejudiced. But he took the advice. As such, he moved to the other unit. And I'm not aware of a situation where Mr. Nesunzi raised a complaint, maybe it would not have come through me. Maybe he would have raised it with the accounting officer at that time, that he was not satisfied, but he did not engage me in terms of the dissatisfaction about his move, except that he was surprised that he needed to move. Thanks, Honorable Member.
Thank you, Mr. Simon Tebele. Just before we reach the end, I now, in terms of 6.16 and 6.17, recognize evidence leader Mayosi. If there's any question, don't have to generate them that you want to check. Advocate Mayosi.
Thank you, Chair. I only have one question for Mr. Tebele, and it's in the form of a request, really. But before I do, Chair, with the evidence leaders, we can't resist putting this on record and noting that we have appreciation for Advocate Mbofu and his team, because today, for the first time with this witness, there appears to be no misgivings about the fact that the evidence leaders assisted the witness with the drafting of the affidavit. But I'll move on to the question/request to the witness. Mr. Tebele, you spoke in cross-examination about the fact that the portfolio committee had often raised questions or requested certain information relating to the rising litigation costs. You said that at some point you did an exercise where you were comparing or looking at the period before the Nkandla judgment and comparing that to the period after the Nkandla judgment, and you formed the view that the Nkandla judgment had an impact in the rising litigation and costs. So I just want to know, did you produce a document from that exercise where you were doing the comparison? And if you did, who is the custodian of that document in the organization so that we may access it?
Are you still with us, Mr. Tebele, or are you frozen? That picture shows a frozen. We'll just pause and wait. Yes. Mr. Tebele is off the platform. We'll wait for him. Yes, that hand will wait for Mr. Tebele as well. That's how we do it. We just do it a moment ago and paused.
As chairperson is a dictator.
and this.
I thought I was muted, Chair, sorry.
Vile, and this cab. Can somebody just interact with Mr. Tebele?
He says there's load shedding.
He has load shedding.
Yes.
Okay. Let's wait for Temimosi to finish that, because all we need also now is him making his last comments and hearing what the black hand will say. I think he is trying to connect. Yeah, you might connect the phone in. It's just 5 minutes. He said he is trying to connect. Okay, he's trying to come in. Okay. Yeah, I know. Mm. I thought he was in the office of the public protector. Because at least to advocate Mbufune advantage, takutshona yena ungena apha kunika public protector. Ndicela umute.
Oh, azova i-secret zethu.
Is load shedding brought by the ANC chairperson?
You've just smuggled something here in this meeting. Okay. That's fine. He's struggling. Maybe we'll do this and ask Advocate Mbofu to just raise a hand to indicate the issue wanted to raise, because what would have been left is for us to thank Mr. Tabele and for him to make share whatever words he wanted to say. That's the only thing left. But before that, as we struggle to get him in, we would have waited for him so that he hears everybody. Advocate Mbofu,
Thank you, Chairperson. Did you manage to get the witness back?
We spoke to the witness. The witness is trying, but to load shedding. We are trying other means to come in. We're still waiting.
Okay. No, thank you, Chairperson. No, thanks, Chairperson. While we're waiting, I just wanted to respond to the statement made by Advocate Mayosi or Majosi.
Yes, we are normal. So respond. We are normal. Okay.
No, I just wanted to place on record that we have no problem with the evidence leaders taking statements. That's what they do. We will do the same thing with our witnesses. The only problem we have is when they feed them with false information, or as this morning, ambush them with gossip. So we will raise those issues as and when they arise. But other than that, we have no problem with them taking statements. Thank you, James.
Thank you. Thank you very much. Colleagues, what we're missing is the last voice of the witness, but we know why we're not able to connect with the witness in his absence so that it is recorded. I want on behalf of this committee and everybody else in this inquiry to thank Ms. Simon Debele for availing himself, participating throughout this process, answering all questions, even if the person who's asking is not happy. We want to appreciate the role that is played, hopefully, his contribution is also going to assist this committee in its final deliberations. Thank you very much. With that, the inquiry is adjourned. We meet tomorrow at 10 when we will be interacting with the witness Baldwin Neshumi. Neshunzi will be with us. Thank you very much. Meeting adjourned.
Yo, Chairperson.
Thank you, Chair.
Recording stopped.
Mr. Futana Simon Tebele, can you hear me?
I'm not sure, Honorable Chair, if I'm in the right meeting.
You are in the right meeting. I'm asking you, we understand you had load shedding. The last thing I want to ask you is for you to just give us your final word about the day. We were fortunately done when there was load shedding. Anything you want to say?
Thank you. Thanks, Honorable Chair. Just to appreciate the time given to assist the committee. Hopefully, I have done that part in terms of assisting the committee, and in my way in terms of assisting the institution and putting the perspective of the institution in terms of the work of the committee. Other than that, I'm thankful and grateful for the opportunity. Thanks, Honorable Chair and the honorable members.
Thank you very much, Mr. Debele. On behalf of the committee, I thank you. I will repeat that. We thank you very much for availing yourself and participating throughout the day. Hopefully, what you have shared with us will be of great assistance to the committee. Thank you very much.
Thank you, Chair.
Thank you. On that note, we adjourn again and we meet at 10.